come forward and take your seat. Good afternoon to all the speakers, panelists, and the participants. It gives me great pleasure to welcome you all to this seminar hosted jointly by Samishti Legal and Alliance for Corporate Counsels and Company Secretaries. To start with, I'll give a brief introduction of Samishti Legal. Samishti Legal is one of the emerging law firms in Hyderabad with specialization in corporate law advisory, mergers and amalgamation, transaction advisory, insolvency practice, and other commercial and legal contracts. Samishti has worked with large number of companies ranging from brick and mortar to mid-sized companies and corporates. Samishti's team consists of interdisciplinary professionals like advocates and company secretaries who together leverage their knowledge, expertise, and experience in providing quality legal services to domestic and international clients across various sectors. Now coming to Alliance for Corporate Counsel and Company Secretaries, which is the brainchild of Mr. Parvesh, I would request him to please come and share a brief introduction.
First of all, let me thank Mr. Legal for arranging this event and inviting us here to have a joint program on IBC. Alliance for Corporate Counsel and Company Secretaries, in fact, is a platform. Couple of years back, few friends thought that we should have an informal platform where we can discuss the latest amendments of law and have a social get-together as well. So we started 5-6 friends. We started meeting together on monthly basis, and then we start including the new members who are the in-house counsels in Delhi, NCR, and outside Delhi also. Now we have programs on monthly basis in Delhi and NCR. We had our program in Mumbai as well, and this is the first program in South India in Hyderabad. And so we generally have covered most of the topics on the recent laws, IBC, GST, and what are the latest topics. So let's hope that this IBC topics will be a good. This event will be a good thought process and a good interactive session. And thanks to Smisty again for inviting us here. Thank you.
Thank you, Parvesh, for the introduction. Now, coming back to the seminar, I think the topic for the seminar is very relevant in the current times, which is Insolvency and Bankruptcy Court, which is the new corporate insolvency regime in India, and NCLT, which is the new corporate jurisdiction. So let me just tell you the flow of the seminar. First, we'll have Mr. Prashant taking seminar on NCLT. Then Mr. Raghu Babu will talk on IBC, and then we'll have a panel discussion. So let us now start the session. I would like to introduce our first speaker, Mr. Prashant Jain, who is the partner of Samishti Legal.
Yeah, thank you everyone for joining us for this seminar today. So the topic which I am going to take is on the NCLT along with the appellate tribunal, which is again tribunal for the NCLT. So how all it started? So it started in 1999 when Government of India appointed a committee for revamping the law which is related to winding up an insolvency, and appointed Justice V. Balakrishna for revamping the entire insolvency law. So Mr. V. Balakrishna along with his committee reviewed the insolvency and winding up law at that time, and then came out with the idea that the corporate has a lot of independent jurisdiction like SURFACI Act, your BIFR, and the other appellate tribunal. So they suggested that there should be a one corporate jurisdiction which should be kind of a final corporate jurisdiction for all the matters related to corporate. So they came back with an idea that the government should form a national company law tribunal, and then all the corporate matters should be falling under the National Company Law Tribunal. So this is how it all started, and then government amended the Companies Act and they brought the NCLT as the corporate jurisdiction in 2002. But again in 2002 this was objected by Madras Bar Association in Madras High Court, saying that the formation of NCLT and LCLAT is unconstitutional and it has a lot of defects, which was again discussed in length at Madras High Court. And somewhere in 2003 Madras High Court came out with a judgment saying that the formation of NCLT is not unconstitutional, but there are defects which have to be rectified before making the law. So there were defects with respect to the officer, what qualification the presiding officers of the tribunal should have, and what are the qualification of the judicial and technical member, which the Madras High Court directed the government to rectify. So after this judgment, again the Madras Bar Council appealed the judgment of Madras High Court in Supreme Court, which was again heard for 3-4 years, and again in 2010 Supreme Court came back with a judgment saying that the judgment of Madras High Court is good to go. So they said the formation of NCLT is not unconstitutional, but yeah, there are defects which have to be rectified before they implement the law. So this is how the NCLT came into formation. So in 2010, with the judgment of Supreme Court, government was given a clear mandate that they can go ahead with formation of NCLT and appellate tribunal. So so the government came back with the Companies Act 2013 along with the rules which will be applicable for the NCLT. So in June 1, 2016, the rules were notified by the central government, which talk about the formation of NCLT, the qualification of the judicial member, technical member, and who can practice as NCLT. So in June 1, 2016, the NCLT was a reality in India. So currently there are 11 benches which are kind of functioning. Delhi has 2 benches, and again you have different benches in Ahmedabad, Allahabad, Bangalore, Chandigarh, and then other jurisdiction. Yeah, just to give you the features of NCLT. So basically NCLT is a quasi-judicial body which is kind of an independent body. So it has the powers like a court, but it is not binded to follow the CPC procedures. So it's kind of a body which is guided by the principle of natural justice. So these are the basic features of NCLT. So this gives them a lot of power with respect to dispensing of a lot of cases based on the natural justice principle. Then again the matters which have been dealt at NCLT level can again be appealed at the appellate tribunal level. So there are timelines under which the matter has to be kind of directed if a aggrieved person wants to appeal that matter. So there is a law for that, which we will be discussing in the coming slides. So when it comes to the composition of NCLT, there is a president, there is a judicial member, there is a technical member. These are the qualifications which have been prescribed. So as I was telling, in 2002 when the government came back with the qualification of the judicial member and technical member, there were a lot of flaws which the Madras High Court and Supreme Court said that they should revamp it, and based on that, their suggestions, the central government revamped the qualifications which are required to be the member of NCLT. So these are the qualifications by virtue of which a person can be the judicial member or technical member of a NCLT. So basically, if a judicial member has to be either the retired judge of High Court or a district judge with a experience of 5 years, or an advocate with an experience of 10 years. So basically, the president is appointed by the central government along with the chief justice. Then the president, then they will constitute a selection committee who will, based on this qualification, appoint the judicial members and the technical members for the NCLT. So here, if you see the PCS, PCA, PCW are also eligible to be kind of be the technical member on the NCLT, but they have prescribed the minimal years of experience which they need to have, which is 15 years. Again, when it comes to the composition of NCLAT, so there is in NCLT you have the concept of president, but in appellate tribunal you have the concept of chairperson. So if somebody has to be a chairperson, he has to be a judge of Supreme Court or a chief justice of High Court. Then again there also you have a concept of judicial member and technical member. There also they have given the qualification how a judicial member and a technical member can be chosen. So just to give you a slight, what do you call, background, who can appear at NCLT. So based on the Companies Act section 432, either the person who is aggrieved, he himself can appear, or the person wants to appoint a lawyer, he can appoint. Here also they have given a kind of a, what do you call, qualification to chartered accountants, company secretaries and CMAs to appear. But if you see the section, any person who is kind of an expert in that matter or who is fit to appear can appear. So it could be anybody. So if you see the definition of 432, it talks about any person. So it's not that it has to be kind of a, somebody has to have a prescribed qualification, but definitely he has to be competent to appear before NCLT. So if you see the powers of NCLT, earlier you had company law board, you had what you call high court, you had Supreme Court, which were dealing with the matters of company law. But after the NCLT came into what you call reality, these are the matters which were with CLB or high court or BFIR, which have been kind of consolidated, and all the powers have been given to NCLT. So winding up, earlier we used to approach high court, respective high court, and then we used to file a petition. But now this matter has been kind of brought into the jurisdiction of NCLT. Compromise and arrangement, again any scheme of arrangement, if any company wants to go through a scheme of arrangement, then earlier we used to approach the high court, but now it can be dealt by the NCLT. Revival and rehabilitation of SIP companies, again BFR was the what do you call the body which was dealing with the rehabilitation of SIP companies, but now it will go to the NCLT. Rectification of races, again a procedural requirement. Earlier it used to go to the CLB, but now it will go to NCLT. Investigation and compounding under Companies Act, earlier it was CLB, but now it goes to NCLT. Operation and mismanagement, again it was to CLB, but now it goes to NCLT. Powers in terms of LLP Act. If you see the LLP Act, there also LLP Act uses in a lot of sections. The LLP Act uses the word tribunal. So the tribunal which has been referred under that act is the NCLT, and the appellant tribunal is the NCLAT. So LLP Act also the winding up of LLPs or any matters which need to be dealt by a tribunal under the LLP will go to the NCLT. So these are the new concepts which have been introduced in terms of the Companies Act. If you see the previous Companies Act 1956, these concepts are not there, but now under the new regime, these concepts have been introduced. Class action suits, which I think everybody would be knowing. Class action suit is a new concept which has come. If any depositor or a member is aggrieved, he can approach the NCLT and file class action suit against the directors or any what do you call stakeholder like auditors or any other consultant by of his advice who has been kind of affected. So this is a new concept, and the jurisdiction again lies with the NCLT. Financially are changing again. If you see earlier it was with the ROC, but now this matter again have been moved to the NCLT. Cross-border merger, again today it's a reality. Earlier cross-border merger was not what do you call permitted, but now any cross-border merger, amalgamation of Indian company with a foreign company is allowed, but you need to have the approval of NCLT. Issue and redemption of preference shares. So if any company has issued the preference shares, if they are not able to redeem the preference shares based on the terms of the issue, then if they want to raise new preference shares, then basically they have to take the approval of the current preference shareholders and approach NCLT and get their approval. Then only they can do this. Reopening of accounts, power to appoint amicus curiae. Again, amicus curiae is a concept wherein if NCLT wants to have an expert opinion, they can appoint a expert who could be a senior advocate or who could be or they can approach the professional bodies like the Institute of Chartered Accountants, Company Secretaries, or Cost and Management Accountant, or any other professional body where NCLT would think that they can get the expert advice. And amicus curiae, again, this is not binding on any court, so they can take the opinion, but yeah, it's not binding, so they can either go with the opinion of the expert, or they can set aside the opinion and go with their views. So this is again a new concept and a power which has been given to NCLT. Yeah. Which are the? That's what I'm saying. If you have issued any preference shares, and if the redemption is happening after 5 years, and if you are not able to redeem that, and if you want to redeem that by issue of new preference shares, so you have to take 3/4 holders approval, and then approach NCLT for their approval. So basically, you are refinancing the preference shares. Yeah, under the current law it is required. If you are doing, if you are not able to kind of redeem them based on the terms of the issue, then it has to be. Pardon? 3/4 of the shareholders have to agree. Then you have to approach NCLT and get their approval. Yes, that is the law. Yeah, but in the current act that is there. Under the Companies Act 1956 it was not there, but under the current act, if you are refinancing your preference shares, you need to get the approval of NCLT. You are issuing new preference shares. If you are doing based on the terms, fine. But if you are not able to pay the maturity amount, and if you want to refinance them, take the 3/4 holders approval and approach NCLT and take the approval. It's a procedure.
Making arrangements or it's a scheme that you are refinancing your redemption. So you are not able to pay but refinance your redemption by issuing a new share that will go to earlier it was you were there and now it was cancelled. Since NCLT has a right to refuse redemption.
But generally, if the 3/4 shareholders agree, I don't see any reason to do it. If there are views of NCLT that the minority shareholders will get hit, then definitely they will take that stand. Otherwise, yes. Yes, right.
But logically, if the promoters are subscribing to those shares and promoters are agreeing to it,
that's what I'm saying. If it's a promoter, then that's what I'm saying. See, there could be two examples here. If a company is there where you have promoters and you also have minority shareholders, then it becomes very important for them. If you kind of, it's a company which has been funded by promoters, then I don't think it's important. But if you have minority shareholders, their rights have to be protected. So if somebody is jacking up the funding of preference shares, then definitely NCLT has to take the view whether it is kind of real transaction or there is something which is done for jacking it up. So that is the view which NCLT may take. So that is the logic by virtue of which the NCLT approval is required. Yes. So as I was telling, this is the corporate jurisdiction, which is kind of a consolidated corporate jurisdiction. Earlier you had BFR, you had SICA Act, where in case of any bankruptcy, the banker had the option to attach the assets. But now after the notification of the Insolvency Code, then this will go to the NCLT. So this is one of the corporate, which is a consolidated corporate jurisdiction for all the matters, and which is one of the basic advantage of implementing of NCLT. So corporate dispute, again, earlier scheme of arrangement, winding up, reduction of share capital, restoration of different companies, variation of rights, appeal against CLB orders, where the matters which lied with the courts, company law matters, again compounding offence, cause and investigation to affairs of the company, matters related to operational mismanagement, where the jurisdiction, where the company law board had the jurisdiction, BFR, and the AIFR, where the jurisdiction for revival of safe companies. So this is the present system. Company law board, High Court, companies insolvency matters will all lie with NCLT and NCLAT. Transition, so June 1st, 2016, this. You have anything here? Transition again, June 1st, 2016, this was a reality. So on the date of the notification, there were a lot of matters which were pending with respect to CLBs. So all the matters have been transferred to NCLT. So NCLT has the power either to start the matter where the CLB has left, or they can reinvestigate and do the entire study of the matter and then take it up. So they have been given the power, but the CLB is dissolved and all the matters which are lying with NCLT have been transferred to the respective bench of NCLT. Yeah, these are some of the advantages which have been kind of listed here. So NCLT is a specialized court only for corporates. Earlier you had a lot of ambiguity, whether a banker should go under SURFACE Act, or he should go under Companies Act for winding up. This gives them some view. Again, if a banker wants to go under the SURFACE Act, they can still go, because SURFACE Act is still there. But definitely, because NCLT is a body where there is a time bound solution. A lot of people could consider this route if in case of a default from a borrowing company. So this is one of the major advantage which NCLT has brought in, along with the insolvency code, which has been recently implemented. So this is one of the what you call critical aspect of the NCLT. Yeah, NCLT will reduce the multiplicity of litigation before different forums and courts. This is also one of the major advantage. Speedy disposal. So there is a time-bound mechanism which has been given in the NCLT rules. So the rules clearly say that the NCLT should endeavor that they dispose of the case within 3 months. But it is not binding, but definitely it has been clearly stated that they should dispose of the cases within 3 months. Yeah, so insolvency and bankruptcy code. So I will not get into much because you have a separate session for that. So insolvency and bankruptcy code was notified, which is 2016, was notified recently. So any matter which is with respect to winding up of a company, the banker has the right to, the banker and the financial creditors has the right to file a petition with NCLT for winding up of the company. So yes, yes. So High Court doesn't have any jurisdiction now. If you are a banker, if you want to go under SARFAESI Act, you can go and attach the assets. But if you want to, wind up the company, definitely you have to approach NCLT. The jurisdiction is the Companies Act, but the the jurisdiction is under the IBC. But because company is a company established under Companies Act 2013, this has been notified through the NCLT. No, you have to approach NCLT. Enforcement of security under what? SARFAESI Act? No, I don't think it has to be under this code. It has to be under the SARFAESI Act. You can go and attach the. Yes. But as a banker, if you want to decide whether you want to go under SARFAESI Act or you want to go under the Companies Act, you have to see the financial strength of the company. If you have assets which can be attached and you can recover your money, maybe you can consider going under SARFAESI. The priority is also different. In the SARFAESI Act, the government dues get priority, but under the Insolvency Act, the priorities are different. So, as a banker, as a lender, if you feel that attaching the assets would make more sense, then maybe people can go under the SARFAESI Act. But if you want a time-bound solution, then definitely you have to go under the Companies Act. But definitely, based on the strength of the company, we have to decide. But because it's a company under the Companies Act, the jurisdiction and the provision which comes will come from the Companies Act. So appeal again, if anybody is agreed with the decision of the NCLT, they can appeal. Under the Act, they can appeal within 45 days to NCLT, and under the code, which is Bankruptcy Code, they have to appeal within 30 days. Again, if somebody is agreed with the decision of NCLT, they can appeal on question of law with Supreme Court. Again, 60 days is the time limit. So this will only be kind of a question of law. It cannot be on the basis of the question of facts. So earlier CLB you can appeal to High Court, but now after the Companies Act 2013 and Constitution of NCLT, it has to be to Supreme Court. So High Court doesn't have any jurisdiction now on the corporate matters. So landmark cases again. There are two cases. So maybe first case we can decide. So NCLT was constituted in June 1, 2016. So after that, I think a lot of people know that there was a conflict between Ratan Tata and Cyrus Mistry. So NCLT dealt with that matter, and there were a lot of hype around this case. So Cyrus Mistry filed a petition with the NCLT Bombay bench and stating that the company is mismanaged and there is an oppression to the minority shareholders. So NCLT dealt with that matter in in length, and then if you see the operation and mismanaged provisions under the Companies Act, there is a minimum prescribed qualification under which you can file. If you are not coming under that qualification, if you are not a shareholder holding the prescribed shares, you cannot go for the operation and mismanagement. But Cyrus Mistry filed the application saying that he is the equity shareholder, which is not coming under the eligibility criteria, but he is also holding preference shares. Preference shares, if converted, will kind of make him eligible, but that plea was not kind of accepted by NCLT. And then again, he also said that it should be taken as a special case wherein the minority shareholders' rights are getting affected, and NCLT should admit this petition and then kind of allow the matter to go ahead. So NCLT dealt with both the cases and said that it's not a special case. It's not a special case where NCLT has the power. If you are not meeting the minimum prescribed qualification, then you can't file an application with NCLT under the mismanagement and oppression. So they have set aside the petition which has been filed by Cyrus Mistry and said that they are not going to admit this petition. Then Cyrus Mistry appealed this case under the to the tribunal. So this matter is still pending with the tribunal. So this is the one of the landmark case which NCLT has dealt with. Coming to the second case, Innovative Industries Limited versus ICICI Bank Limited. Again, there was a dispute. If you see in my previous slide, I said that NCLT is guided with the principle of natural justice. So basically, natural justice is a principle where the opportunity has to be given to the opposite party to be heard. So in this case, the opposite party said that at every stage you have to give us the opportunity. At the admission stage, you have to give us the opportunity, and at the time of disposing the case, you have to give us the opportunity. But NCLT said we are guided with the principle of natural justice, but we are not guided to give you opportunity to be heard at every stage. So at the admission stage, they have taken the facts and records and they have decided the case, and they said no, we will admit this petition, and at the the stage of the order, they have not given the opportunity to be heard. So on that ground, they said they have approached the NCLT and said that NCLT has not given us the opportunity to be heard at the order stage. So NCLT has put aside the the views of the appellant and said that no, NCLT is only guided by natural justice and they will collect the facts and then they will decide, but they will not give you the opportunity to be heard at the every stage. So this was again one of the landmark case. Again there was a recent case on SR where again SR said that the authorized representative of SBI has not signed the application and the application is defective. On that ground, they wanted the Ahmedabad branch to reject the application, which is still pending, but I think that should also not be a ground wherein the application of the banker should be rejected. Again, there are other matters with respect to whether if a company has an arbitration award, still whether they should go under the arbitration proceedings and enforce the order, or they should, if they have an opportunity, they should go under the NCLT. So those matters are still to be settled, but if you see, arbitration or winding up of a company, they both are separate. Arbitration is a mediation, mechanism wherein both the parties are sitting together and deciding, and the arbitrator decides. But winding up is a process where you say that the company is insolvent and they will not be able to honor the payment of the outstanding amount. So both are different. So if you have an arbitration order, still you want to go under NCLT, you can still go. These are some of the challenges, if you see. So I don't see much, with respect to challenges when compared to the previous act where you had multiple laws. But still, if we have to list some overburdens of appeal now, in Hyderabad bench also you are seeing that there are a lot of cases which are pending. Now, under the new companies, a lot of companies have been striked off. So if a company has to revive, then they have to approach the NCLT. So currently there are 20,000 companies which have been striked off. If out of that 10% of the companies wants to get revived, and if they file petition with NCLT, I don't know whether NCLT will have that kind of bandwidth to support the the cases. So that is one challenge wherein the overburden is on the NCLT. Then again, question of law, as I said earlier, you had CLB where if you are agreed with the decision of CLB, you can approach High Court. But now you have to approach Supreme Court, where there also you cannot, if you are able to prove that there is a new fact, maybe a Supreme Court will consider. Otherwise, Supreme Court will say that they will only deal with the case if there is a question of law. Otherwise Supreme Court will not deal with that. So these are the two challenges in NCLT. Otherwise, NCLT is a very good reform which has been brought by central government. If it is implemented with a true spirit, then definitely it will change the entire way the corporate operate, and it will also give a lot of strength to the bankers where they are kind of suffering with a lot of NPS, where if under the early act it took a lot of time, but now under the new act it is a time bound process and they will get a lot of relief. My views on the insolvency code. Insolvency code is good, but definitely there are challenges, because if the petition is admitted, then the company will be run by the insolvency professional. So I think that whether insolvency professional is competent to run the company, whether he understands the business, that is very important. So that is my view. Thanks. Any other questions? yes, sir. Delhi High Court on the strike off is saying that they have kind of stayed that. But what I feel is they don't have I don't know what Delhi High Court has done, but my views are they can't do that because before the what do you call ROCs have striked off the company, they have given enough time to the companies. So if somebody has received the notice, if he is aggrieved, then he should immediately what do you call approach the respective High Court and get a stay. So I don't think Delhi High Court will give the stay because they have been given enough time. So on what basis Delhi High Court will give stay, I don't know. So the act of the central government by striking off the company is good because they have given enough time and they already have a power under Companies Act. So that should not be a problem for them. If they would have not given the time, then maybe there is a problem. But they have given a respect. You can't even tell that I have not received the notice because they have put the entire list on the website.
I read a news cycle. Winding up proceedings are pending with the High Court. There is no jurisdiction of IBC.
No, all the matters will be transferred. Yes, yes.
Why 15 December? Then it will continue with the High Court. Other cases will shift to the NCLT. That's what I was. But other there is a big issue like if the winding up petition is going to the High Court and here new NCLT business has been started. So if winding up is admitted by the court, then there is NCLT issues all over. Like no one can take the lead.
But I don't know whether it's a recent what do you call development. But the cases which are there with the High Court have been transferred in Hyderabad.
Yeah, only those cases which are going to be served is 15th of.
Okay. Okay. That should not be covered, no? Modification of terms? Yeah. Yes, yes, yes. Yes, correct. But modification, if the holder agrees, you can go through the normal process. You have to take the holder's approval and take the board approval and go ahead. So they should not. It will be if you are issuing fresh shares for redemption. Yeah. So that will be the. Pardon? Yeah. So yeah. So that will fall under NCLT. But if you are modifying the terms, extending the term, taking more time for redeeming, it will not. But if somebody wants money, you are raising fresh capital, fresh preference shares for that, then definitely you have to go to NCLT with the approval of 3/4 holders. See, convert, no problem. But only thing is the trigger will happen when you are taking what do you call you are refinancing the previous preference shares. Then you have to go to NCLT. But if you want to convert, change the term. Pardon? See, that's what I'm saying. So we have to apply the principle of whether the minority shareholder or promoter is jacking up. Otherwise, maybe I can get back to you. Yeah. Anything else? Right, thanks.
Thank you, Prashant, for that very informative presentation on NCLT. Now, I would like to introduce our next speaker of the seminar, Mr. Raghu Babu Gunturu. He is an insolvency professional registered with Insolvency and Bankruptcy Board of India and is a mentor and advisor of Samishti Legal. He is also a fellow member of ICSI and has done his executive MBA from ISB. He has over 20 years of experience in various matters relating to setting up of business in India and overseas, capital restructuring, domestic and international listing, FDI, joint ventures, foreign collaborations, transaction advisory, M&A and advisory on corporate legal matters. Raghu sir has closely seen more than 500 companies in various stages of their life cycle to across sectors like brick and mortar, new economy, sharing economy, and has worked with a number of promoters, entrepreneurs, and professional managers. I would now request Mr. Raghu Babu to please come and start the session.
Very good evening, friends. Thank you so much for all of you having come here and spending some time with all of us, learning together. I mean this I want everybody to keep in mind for my session till we end. Learning together. This learning together. And maybe I may share a couple of my thoughts on this subject, but most importantly, there are a lot of speakers in the other side of the a lot of experts and the even the other side of the in the audience too. And the whole idea is stimulate and learn collectively. That's why I said learning together. I just want to give a little bit context. When I say context, sometimes I take a very, very larger context. And I take a context as the India as a country. We are going through a very, very transformational phase. I keep saying whenever I give a lecture, we are in a transformational phase for multiple reasons. I mean, that can be explained in maybe 2-3 things. We are moving from cash to white, black to white, organized to unorganized, roti, kapda, makan, and mobile. These things speak a lot from where we are, where we are going, where we are today. If you see Prime Minister Modi when he visited US first time after he took over as the Prime Minister of India, he went over US and said 3D advantage. India has the 3D advantage, right? I think most of you would have read and seen. What is this 3D stands for? Largest democracy in the world. Digital, the demographic dividend, the youngest youth population, and the demand. That is what today India represents. We are growing 7+, and we think we will grow maybe next few decades 7, 8, 10%. I consider very, very fortunate to be part of India and part of this generation. I suppose you all think that way. That gives a lot of pride and the confidence and satisfaction that we are in this part of generation. That's on the Indian context. Now the context coming to the IBC. I never knew that I would write I'm an insolvency professional till January 2017. But today, now every day this is my part of my life. That's how the things are started moving in the insolvency arena is concerned. We had the demonetization, we had now the IBC, we have the GST. We are all part of the this professional business community day in, day out. We are part of the businesses. You see any business newspaper or the electronic print media, without insolvency there is no reference. That is the importance of this topic. With 6 months old, the first case got filed on 17th January, we are today maybe 28th July, just 6 months. This legislation is crawling. There are no answers. There are a lot of questions, there are no answers. But maybe it will evolve. The chairman of the IBBI himself admits it is not perfect. But we can't make it perfect from day one. Let us implement it, let us work together and see that we will address some of these issues and become perfect. That's the context with which we should keep this subject in mind. When we want to do this seminar, what was the objective? One, obviously want to get a little flavor of NCLT as the single jurisdiction. Second, IBC and insolvency code, how is that relevant? Why should we speak about it? Why should we understand about it? I am not insolvent company. I am very, very strong. Does that mean anything to me? Why should I spend my time on this subject? Right? When we talk about insolvency, bankruptcy, sometimes we think it as is little taboo. It's a negative. Maybe things are not going good. It's like a in the sense as a human being, you have an ailment, you don't want to have it, but you have it. But doesn't mean that you don't need doctors or hospitals. So you will have the situations. We know we wanted to be profitable, we wanted to be very strong, we never wanted to get into an insolvency. But I don't think 100% of times it is possible. So the success and failures of the business is part of the game, and we all have to realize and be part of it. While I am strong, I don't know what is the fate of my supplier, my debtor. So how is that going to impact me? See, the whole purpose of this seminar, maybe next minutes I wanted to share some of the very, very conceptual government which says We are at 187, we are at 200, we are working towards, next year we'll try to bring down. First time, out of last 22 years of my experience, this government started doing very, very closely ease of doing business ranking, which was there at, 187, now it is 130. Now this takes multiple factors in ease of doing business. Ease of doing business also mean ease of closure. While the World Bank does the reporting and the ranking, they consider all these factors. We have been doing very, very badly on closing these businesses if there is a requirement. So that was one of the factors which drove, having the new insolvency legislation. I mean, we all know the stress loan portfolio. I mean, it's anybody's imagination. What is being reported? What is actual stress? Is it 8 lakh crores? Is it 10 lakh crores? Is it 16 lakh crores? Is $1 million question. But at least we all know it is more than 10 lakh crores. Now, again there, I mean, what's happening? We have been postponing the problem. It's like, I've been telling, like a Swachh Bharat, it's a Swachh banking. IBC is one weapon to bring Swachh, maybe public sector banks or Swachh bank or Swachh banks without NPA. Clean up balance sheets, we all know. I mean, the lot of companies' balance sheets got over leveraged, and there were opportunities, people could raise money, got leveraged, and all of them are sitting huge liability, unrepresented assets, unrepresented businesses. How long you can sustain? One day it has to bust, and then see that you become thin. So that's the another challenge we have. I mean, multiple laws to deal with the insolvency, which we will see in a couple of minutes. And another very, very important thing which this law tries to do, time-bound resolution mechanism. Either you call it a insolvency or the liquidation, time-bound. I mean, we all know it is not having good law, it is also good implementation which matters. Not that we don't have legislations, we have umpteen number of legislations, but thing is we lack in implementation. So, I mean, the DRT is another example, securitization another example, we have CDRs, we have SDRs, so many things, but lack of effective implementation, where the things are taking. Morning I was at the Dr. Reddy's AGM, Bharat Doshi, is on the Reserve Bank board, and he was part of the, he was the Director of Finance at Mahindra & Mahindra, and the, part of the Reddy's board. I was interacting with him, and I wanted to hear his views on the IBC, given he's in the RBI and, very veteran, finance professional in the country. He said, I mean, everything looks good, going good, but we have to ensure that this won't get derailed. The adjournments keep happening, it gets postponed, then we see, DRT kind of a situation. So I don't want to spend too much of time. I mean, this, speaks volume in terms of the NPA. Some of the banks now have been put under vigilance that, I mean, they can't lend further, they can't open branches further, given where their capital adequacy ratios are. Very, very alarming situation. We have to, I mean, I think maybe government also realizes it is very, very alarming. We have to address this problem. We can't postpone further. Even government is very, very aggressively pursuing to get rid of this, NPA menace. I mean, these are the multiple schemes which are available to the bankers, to restructure the loans, stressed assets and all that. I'm not getting into the details here. Yeah, I mean, this is, what used to be the, insolvency regime and what is being done under the IBC, Insolvency and Bankruptcy Code. I mean, this been made reasonably simple. Now everything, all insolvency in the country comes under the Insolvency and Bankruptcy Code. Any kind of insolvency, as an individual or HUF, partnership firm, LLP or companies. Now all of that is put into two buckets. One, companies and LLPs as corporate persons, which will be driven under the NCLT jurisdiction, and rest all individuals, HUF, and the partnerships, unregistered partnerships. I mean, the partnerships under the Partnerships Act will be dealt, through the DRT, which are yet to be notified. Only what is notified is the insolvency resolution process for the corporates. Yeah, this is again a little bit on the context, I mean, where we stand as a country versus rest of the world. Ease of doing business, I mean, 2017 we moved to 130, maybe we may move, I mean, government target is go to 80 in next 2-3 years. Cost of liquidation and then the recovery rate. I mean, another objective of a good insolvency legislation is how do you bring back the unproductive, partially productive assets into productive use. I mean, that's another. And also, in the case of liquidation, how quickly you can recover. The 100 rupees as a day, you declare the liquidation, how quickly you can recover, how much you can recover. Can you recover 100? Can you recover 90? Can you recover 80? We have been able to recover 26 rupees against 100 the day on the liquidation, is ordered. I mean, that's the traditionally. Hopefully, under IBC, it should get improved. Time taken for liquidation, I mean, is a 4.3 years, is traditionally, where it used to go to High Court and all of that. Yeah, this we looked at. I mean, these are the four, striking, objectives for which, by which the code has been enacted. Revival before liquidation. I mean, this is very, very important to ensure revival before liquidation is what is called as insolvency, also called as a corporate insolvency resolution process. This job was earlier done under the SICA by the BIFR. Now that is coming under the IBC. Objective is very, very clear, IBC objective. I mean, to promote entrepreneurship. I don't know any other legislation in India which says, legislation is made to promote entrepreneurship other than the maybe Startup Act. Maybe good to see government is thinking about the entrepreneurship. To make credit available, to balance the interest of all stakeholders by consolidating and amending the existing laws relating to insolvency and bankruptcy, to reduce the time of resolution of maximizing the value of assets. This is very, very, a big key driver. I just wanted to, read a quote from MS Sahu, the IBBA chairman. I mean, he's been very, very vocal, and he made so simple what is IBC. Markets need freedom at a broadly 3 stages of a business: to start a business, free entry; to continue the business, fair competition; and to discontinue the business, free exit. I mean, whole IBC is free exit. If you are not you don't have merit, you are not able to survive in the open market, you should be able to exit as quickly as possible. That is the mechanism IBC, is willing to offer. These are some of the very, very, important highlights. I'll just, touch up of, 2-3 things, and then we'll get into other slides. The code brings a paradigm shift from debtors in position to creditors in control. And I'll elaborate in the subsequent slides, which is going to come. I mean, time-bound resolution process at each stage. Insolvency test moved from erosion of net worth to payment default. This is very, very, very important. Under the BIFR regime, your entire net worth should have been eroded. Only then you could have gone for a revival. Today, the test itself has undergone change. If you have, if you have defaulted, as a company, you have defaulted 1 lakh rupees or more to a financial creditor or to an operational creditor, then you can be dragged to a NCLT for the admitting under the insolvency process. Yeah, I mean, we'll be covering these things in the subsequent slides, so I'll not go into the details here. This I was mentioning already. I mean, entire insolvency is broadly under the 2 categories: corporate person, companies, and LLPs, and the individuals and partnership. Only the corporate persons has been notified. Individuals and partnerships is yet to be notified. I mean, the IBC talks about these 5 pillars for the success of IBC in India. I mean, one is the Insolvency and Bankruptcy Board of India, which is a statutory body constituted under the IBC, which is manned by this gentleman, Mr. MS Sahu. He was the SEBI executive director. He was the part of the Competition Commission, and very, very successful bureaucrat, and very, very demonstrated track record. And we are able to see his drive. I mean, he's on it. I mean, the speed at which he's going is amazing. Whether governments can move at that speed, fantastic job he's doing. There's a lot of expectation. And then the adjudicating authority under the IBC is the National Company Law Tribunal. All the matters under the IBC where with reference to the corporate person, the adjudicating authority, the NCLT and NCLT. Insolvency professional agencies. Now, the IPC recognizes or, has a requirement of two professionals. One is the insolvency professional, the other one is the liquidation professional. Now, insolvency where you wanted to revive, liquidation where you are liquidating the company assets and distributing it. These are the two roles IBC identifies. So how do we, who should be the insolvency professional? Who should be the professional doing these two roles? That is where now the code talks about the resolution professional. Currently, who is the resolution professional? Resolution professional today, there is an online exam, somebody with 10 years of experience, any professional or a management graduate with 10 years of experience can take this exam and enroll with the IBBI as the resolution professional. They are the people who are authorized, to be appointed as the, insolvency professional or liquidator by the NCLT. To govern this profession, these agencies have come, insolvency professional agencies. Insolvency professionals are like me who are enrolled with IBB as the insolvency professional. Information utilities, this is another leg which has not become functional yet. Now the idea is, if there is a default, who has to prove there is a default, who has to prove there is a debt. Now the government want to bring out, maybe digital information utility platform where the financial creditors, operational creditor, companies keep feeding the information. If there is a default, as already established, is in the public registry like maybe ROC or a, there is also other registry which RBI manages. So they have a data. So there is no, proving the debt should not be an issue. That is already given. There is a public registry which is doing. Therefore, your ability to move the applications quickly, all of that. So this is yet to be functional today. So I just wanted to, kind of take you through a couple of definitions. The complete creditors are, categorized to two categories, financial creditors and operational creditors. What rights they have, what obligations they have, what decisions they can drive depends upon whether you are a financial creditor and operational creditor. Financial creditor is a person who has given the financial debt. What does the financial debt mean? This definition gives very, very important thing which is here, which is disbursed against the consideration for the time value of money and includes. This is very, very important. Say if you are an operational creditor which has taken a, subsequently a color of the financial debt, you will not be considered as a financial creditor. Therefore, you will not get those rights. Mostly all, the banks, financial institutions, NBFC, all their lending falls in the financial debt. The key thing is there has to be a debt, there has to be a default of a lakh of rupees minimum. Then that is a trigger that can trigger for an insolvency either by the operational creditor or by the financial creditor or the corporate debtor. The company itself can go and apply for the insolvency to the NCLT. We all understand who are the operational creditors, financial creditors who gives you money, and the operational creditors who is providing you services, who is providing the goods, where you are buying raw materials. All the dues to the even government comes under the operational creditor. Your employee salaries comes under the operational creditors. Currently, I am handling one matter where I have been appointed as the insolvency professional by the NCLT. I have been appointed on 15th of March. Today is almost 3.5 months of experience. Very, very enriching experience. There are still a lot of questions to be answered, but at least there is a fair amount of knowledge. How this process goes, what are the challenges, where there are no answers at all, what we need to kind of put up best practices. That is where it is. And, that gives me maybe a little more edge, in talking, a little bit more confidence here. As I said, the diagram could be this thing. The whole corporate insolvency process, there are 4 phases. First phase is the admission phase, then the insolvency phase, then the liquidation phase, and even before the admission phase. Now, I'm repeating, but idea is to get this basic right. If the company defaults 1 lakh rupees or more to an operational creditor or a financial creditor, this could be a trigger for the corporate insolvency process. This trigger can be initiated by the, the default is to the bank, but the operational creditor can initiate. Default could be operational creditor, the corporate debtor himself can initiate a, corporate insolvency process. Once you make the application to NCLT, within 14 days, it has to be judged, whether it is a fit case, whether it is meeting the criteria, whether there is a debt, whether there is a default, then this can be admitted. Now, while the law says 14 days, yes, Narendra. Yeah, it is not the financial creditor NOC. What it says is you have to prove that that amount has not been paid to you. From your bank, you have to get a certificate that no amount is paid. From your, as an operational creditor, you have to get a certificate from your bank that you have not received this money from your banker. We'll get there later. Huh?
They require to give an NOC to the operational creditor for filing this application.
Yeah. So that's why I said a lot of experts that side also. My job becomes easy.
You have to file those two things. One is Form 3 and Form 4.
Right.
Invoice for this, 10 days they take away gap.
Right.
Then they can file to NCLT.
Yeah. Yeah. So the application can be filed by either operational creditor or operational, financial creditor at the company. Then within 14 days it has to be admitted. Now, why I'm spending little more time on this is very, very important. It only says a notice has to be served on the other party, the respondent or the company. But opportunity need not be heard. But now NCLTs have taken a view that there has to be natural justice and opportunity has to be given. It's good. So opportunity will be given. Once it is admitted, unlike other debt recovery proceeding, you still have an option to trace back and settle and close the matter. But here, once the company is admitted into CIRP, assuming a bank A, SBI going after company B, and filed for an insolvency. We have a recent case. There are multiple cases. Before the admission, the settlement can happen. As a bank, I wanted to initiate a CIRP against my customer. I have issued a notice saying that if you don't pay by so and so date, I can also consider going to the IBC. Before I make an application and before the application is admitted, there can be a settlement. Assuming the settlement has not happened, it has been admitted by the NCLT. Now the lender and the borrower together cannot do anything. You cannot take back. It is an auto mode. Only one exception which came yesterday, I think yesterday or day before, a Supreme Court passed an order, a judgment, against the NCLT order, which said, which we have to see whether it is universally applicable for all cases or only when you go and get that relief from the Supreme Court on a case-to-case basis. What it says, the applicant and the company can get into a consent, and the consent, through consent, it can be withdrawn. But that power, is not available to the NCLT and NCLT. Only maybe when you go to the Supreme Court may entertain. So earlier that was the views taken, but yesterday the Supreme Court order came, I think under 143A of the articles, Constitution, I think they derived that power. But otherwise, you will not be able to get back, trace back, withdraw. Then is auto mode. We will talk about the auto mode later. So you file the application. If there are, if there are any defects, the bench can order for you to rectify, and after that it will be admitted. And while law says 14 days, maybe in Bombay it's happening quite fast. Bombay bench, maybe if not 14 days, maybe 3 weeks, they are admitting our rejection. But benches like Hyderabad, it is taking 2 months, 3 months. Everybody is in the learning process. It's fine. Well, let us take a scenario and go through this process little bit, CIRP, assuming that application is admitted. So if the financial creditor making this application, he is not only has to make the application, he has to recommend a resolution professional who will be appointed as an interim resolution professional. I mean, when the financial creditor makes an application, he has to make an application saying that I am going after company A, we want company A to be put under the CARP. I am also recommending this gentleman ABC to be appointed as the interim resolution professional. Once this order is passed, once the NCLT admits the application and admits the application, that is the commencement date for the corporate insolvency resolution process. Once you say this is a commencement date, there are a lot of activities which get triggered. One, there is a moratorium to the company from all other recovery proceedings, all other civil recovery proceedings, there is a moratorium to the company. Assuming there are 5 banks, 10 banks, NBFCs, any recovery proceedings, any money recovery proceedings against the company, all civil matters get started. Company gets 6 months moratorium. That's one. Second, this interim resolution professional has to take over and he has to give a first public notice calling for the claims. Now, when we say claims, claims of all categories. When I say claims, sir. 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 Banks who? Guarantors, absolutely. This is very valid, very. Yes, sir. Right, right.
I am of the opinion that this NCLT, is applicable to creditors also provided the due guarantee in relation to the debt committed to company.
Right, sir. I mean, very valid point. But the currently as it stands, looks like the moratorium is only against the matter. Yeah. Yes. Right. Yeah. I mean, in India, the way lending is done, I mean, it's mostly the promoter's capital and the bank's capital. Institutional capital is very less. In every situation, most of the times, you have the personal guarantees and other personal collaterals. So whether moratorium applies to even the personal guarantees and the personal collaterals was the question. Today it is not applicable, but I mean regulations say which are not notified. When the individual's insolvency gets notified, what it says is the guarantor's matters also should be dealt by the NCLT, given where the corporate debtor is already going through the corporate insolvency process. Sir. Right. Yeah. Right. Sir rationale is very important. Loan is taken by the company. Company is undergoing the insolvency process. The whole purpose of insolvency is revival. Why are you going after the personal guarantees and the personal properties while you are talking about a revival? I mean, it is a structural, conceptual right thinking. But today there is a gray area. But I think we have filed under the CARP. At least I think banks are not going after the personal properties. They want the resolution to happen. It may so happen. I mean, there could be. Yes. Yes, sir. Yes, it's a very valid point. If this is not addressed, this nuisance may still continue. I mean, if you call it a nuisance or whatever, it can still haunt the promoter I mean, so it's very valid point. I think government must be hearing. Yeah.
Because what happened is one of the case in Calcutta, REC went against the guarantor of the company.
Oh,
The promoter was a guaranteeing, given the corporate guarantee.
right.
So the down the line company is under DRT and some resolution is yet to come.
Right.
And they initiated the insolvency process against the guarantor. And
Right.
their application is admitted.
Right.
So there is no to NCLT where they debated that if my subsidiary company will come with a solution in DRT, then what is the logic of going insolvency against me?
Right.
I am a running concern, so that matter is yet to be decided by NCLT.
Okay. 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 Yeah. So what is going to happen once the this application is admitted, company is declared as going through the insolvency process? This moratorium is very, very important. In some form, it maybe is good that the company gets a relief so that they can think through and put a right plan, and they don't need to go after this recovery process. They get some breathing space. That's a good thing which is happening in the moratorium. But moratorium will not be available for the criminal cases. If there are check bouncing cases, any other criminal matters, the moratorium is not available. And the interim resolution professional, I mean, as I said, has to call for the claims, give a public advertisement and call for the claims. Claims are, from everybody. Anybody has a claim against the company, financial creditor, operational creditors, which includes the employees, workers, present, past employees, and your operational sundry creditors, I mean your raw material suppliers and services suppliers, and the government, including the government dues. Government also has to submit when the claim is asked for that this month's amount is due for government by this company. But today looks like governments have not realized. We'll have to see how government is going to, and this legislation is having, I mean, the way it is worded, they have the overriding effect on a lot of other legislation, including the state governments. We have to wait and see how the state governments are going to behave. We'll talk about it a little later. Once the claims are called for, the claims have to be assessed and the claims have to be admitted on a particular date. Assuming it was admitted on a particular date, maybe 1st of July. On that date, everybody has to submit the claims in 14 days of the paper advertisement that the claims have to be submitted. Claims have to be submitted and then it has to be admitted. So that is the claim money these stakeholders will get in the resolution plan or in the case of a liquidation. So claim activity is very, very critical. I mean, I am a supplier to a company which is going through a insolvency. I have to ensure that my claim is submitted. Not that I am going through the insolvency, somebody else is going through, but I am a supplier. But if I don't submit, then I am not, it's difficult, you may not be able to recover, while the funds are available. Even if it is the books, if it is not submitted, if it goes through NCLT judges it, maybe lack of information, it may be entertained. But otherwise it has to be submitted. While it is there in the books also, claims have to be submitted. Yeah. Yeah. I mean, so this is an evolving stage. Now, if you want to drive a time-bound manner, now every stakeholder has to perform. So first thing is you ask for the claims. Then the second simultaneous activity for the insolvency professional is to get the valuation of assets to be done by two valuers. Assets, we mean everything on the asset side. It could be tangible, intangible, machinery, land and building, all of that. Again, this is going to be very, very humongous activity, and the valuation has to be realizable value. Should this company go into liquidation, what will be the realization? I mean, I've been talking to the valuers, for the current matter. I mean, making everybody understand it is not the going concern, it is the assumption which we have to apply. Should this company go under liquidation, what will you recover? As a going concern, I may recover 100 for 100. But today, if I want to liquidate it, whether this 100 will be 100 or it will be 90 or it will be 20.
The objective is not liquid without the vote. The objective is to recover the company back into the
Exactly. But that is the objective. but the idea of getting the liquidation value is for the resolution plan, overall scheme of things. We'll understand. I mean, what is the significance of, while you talk about a revival in the insolvency process, why do we need a liquidation value is a valid question.
Bankers have a concept already. They call for distress value.
Ah, yeah, bankers have it. I mean, whenever they get a valuation, the distress value, all that. More or less, distress value and the liquidation value is the same.
So can you share your experience in that case?
Yeah.
How you take over the claim of the company?
I'm coming. I want your name. What's your name?
CA calling over. Insolvency.
I'm good. I mean, so you and I are in a, I mean, maybe 2 steps ahead of rest of the people here. Idea is to get the concepts right. We will discuss in the panel and all of that. Once you have the claims, then the first thing has to be done, you constitute a committee of the creditors constituting the financial creditors. It only talks about the financial creditors, it doesn't talk about unsecured or secured. Everybody who has given money are at par in the creditors committee is concerned. Independent financial creditors. I mean, if you have a group company which has lent money and all that, all related parties are excluded. Only the independent financial creditors who have lent money, who have submitted the claims, they all become part of this creditors committee, which is very, very, very powerful. So the interim resolution professional role starts with the calling for the claims, initiating the liquidation value, getting the liquidation value, and it also talks about the management affairs of the company, and then constituting the committee. From the insolvency commencement date and constitution of the committee has to happen within 30 days. Once the committee is constituted, and committee is in de facto control of the company. One thing which I missed telling was, once the order is passed, the board gets suspended, the company board gets suspended. IRP, interim resolution professional, takes over, and he has to do the he also has to take care of the management affairs of the company and constitute the creditors committee. From the creditors committee is very, very powerful. Management in de facto is in control of the creditors, and interim resolution professional as a trustee representing maybe government, maybe the creditors, drive the decision making and do whatever needs to be achieved under IBC. So as I said, COC is very, very powerful. Yeah, please. The company doesn't have the financial creditors. The operational creditors, constitutes the committee of the creditors. Thank you. And 75% of this committee has a decision making power. What do we mean by 75? Based on their clients. If the 100 is the total clients, the people who are having 75% and more will be able to drive decisions in the creditors committee. CIRP for 180 days and which can get extended by another 90 days, 270 days. I mean, again, IBBA also came out with, where, the companies are very small, they don't have a lot of creditors. Fast track CIRP, which can be done in 90 days. Maybe startups, they don't have much claims and all that. That also has been notified. Now, this is the committee of creditors which I was talking about. Apart from financial creditors, following can attend but not vote. Members of the suspended board, they have to be given an agenda and they have a right to attend while they don't have voting right. One representative of the operational creditor, only if they have more than 10% of total debt, they can attend. So what do we mean by moratorium? Yes. We'll discuss.
I think there is a role they have to define and which role they have to present there.
Right.
That role they have to define and as a director,
Ah.
after secretary, after secretary,
Right.
can participate whatever it is.
Right.
One thing, just because I have provided a services and there is a due, I am not an operational creditor, right?
You are an operational creditor.
No, if I read the definition of operational creditor,
Right.
it says that essentially it says and central government, state government and local government.
Right.
So individual is
Ah.
not an operational creditor if I am not a central government.
No, why not? If I provide, please.
So that end interpretation is was a big challenge earlier, but that has been decided that end is not mean for central and state government only. That end is for the last line that end is used for the central state government, but first line of the definition is any individual any service provider is the operational capital.
No, even the employee salary case, employee has gone against the company where he was serving, and that has been admitted now. So that amounts to an operational creditor.
So the end is only with respect to the
Yeah.
Portion of that definition. You see the definition, there are two portions. Last portion of definition is used with central government and state government.
So moratorium talks about these four things. As I said, all other recovery proceeding gets stayed, and this company cannot alienate any property, dispose any property during the moratorium. And the recovery of any property by an owner or a lessor. If the company is operating from a lease premises, the landlord cannot enforce termination or cannot ask the company to vacate. I mean, the protection. 6 months you further live without making payment. This moratorium ends simultaneously with the insolvency process, either 180 days or 270 days when the insolvency gets completed. I mean, this is the role of the insolvency professional, which is expected in the CIRP process. This is a big statement. Management of operations of corporate debtor as a going concern. This is what is expected from the insolvency professional. You manage the affairs of the company as a going concern. Now, in my own experience, the matter which I am handling, they are doing a minimal turnover. 2-3 years back they were doing 300 crore turnover. Today they do maybe 10 lakhs, 20 lakhs kind of a turnover. There is senior management. Not that you sit in the CEO chairs, start taking decisions. You have that kind of authority, but idea is you don't destabilize, destabilize, and whatever is needed, what is in the interest of the company to revive as a going concern, you can take those decisions. That is what expected. Maybe you create a control mechanism to see that things are happening, fairly, judicially, transparently. Nothing is going wrong. That is what is expected. We don't know. It is still evolving. Now, some of the creditors might say, we are in control, and then you are a resolution professional. Why don't we go for expansion? Why don't we sell up this? Why don't we drop the prices? Why don't we increase the prices? I mean, entire, the companies are in multiple categories. Some are dormant, some are very, very hyperactive. The insolvency test is done and it has become, insolvent company. But there may be a lot of operational decisions which has to be done. You can't, keep it in limbo for 180 days. Maybe the senior management, maybe promoter may not be formally, but he can, he has a stakeholder, he has an equity. Maybe collectively you start, driving the decision making. And these are the other, statutory responsibility of the resolution professional. I mean, your life can become very, very miserable. Depends upon the profile of the financial creditors, how many financial creditors are there, whether their interest is aligned uniformly or their interest is, misaligned. Sometimes it so happen with a financial creditor A, it is an NPA, financial creditor B, it is not an NPA. And you have drove, this company into insolvency. I don't want to come with you. And there are consortium, there are, joint lender forum, which have, traditionally have not become very, very functional for whatever reason. Maybe scrutiny or maybe, not having enough courage to take decisions. We have seen all that paralysis. Resolution professional is, very multidisciplinary kind of a role which is expected. It can become very, very challenging. It can take a lot of your time based on, the kind of, the profile of the company. Yeah.
So I have a question here.
Yeah.
So he still resolution professional, is preparing a plan, right? Yeah. He has to get that, approved by the creditors, or he has got the final say to that. Because ultimately he has to give it to the NCLT.
Yeah. It has to be approved by the financial creditor, having 75% of votes.
So there is that's the reason perhaps there's been additional 90 days. But if it doesn't happen at all, because then you have a consortium of lenders, it can become very difficult.
Right.
Yes, sir. In the first two cases, 90 days were already extended also.
Yeah, three, 4 cases which were filed earlier in the beginning, in January and all, they already got extended.
Determining this voting share,
Ah.
is there a cutoff date? Because the right gets varied. The fellow doesn't come within how many days?
14 days.
14 days.
Yeah.
But you give some extra time.
Yeah, we
So
can
your
give.
job there gets the rates, voting shares get variation if you allow someone after the cutoff date.
Yes. But the claim has to be on the commencement date. The claim cannot, an amount cannot undergo change. When instead of accepting in 15 days, I may accept in 20 days, 30 days. See, that's a genuine claim. In few days of delay, should not be denied. But even you can go to NCLT, maybe get a permission and all of that. Yeah.
One doubt here. What is the trigger point for insolvency?
Yeah, insolvency trigger point, you came a little late. So,
Any financial creditor or operational creditor?
if a company defaults 1 lakh rupees or more to an operational creditor or to a financial creditor where there is no dispute, then this can be a fit case for a trigger, where either company or financial creditor, operational creditor can go to NCLT and put this company for a insolvency. That is the trigger. Due for payment. There is, courts have also decided that there should not be any dispute. If it is a dispute, then they are not admitting. Yeah.
Also mentioned about the company can go itself to the
Yeah, insolvency.
what will the trigger there? Because
Trigger is you want to buy peace of mind. There are 21 people. So many financial creditors, operational creditors. Now, there are different motivations. One, if the financial creditor is going, it's good. But if they are not going, they are still watching, and then maybe their recovery rate is better. Company has solid assets, and maybe collaterals are better, personal guarantees are better. I am not thinking I should go today. But you think, maybe I want to buy peace of mind, it is already defaulted, there is a default, you can go and come under insolvency. But where are other stigmas, are there any attached, and we'll have to see. Yeah.
you are saying some 1 lakh rupees.
Ah.
Suppose you have 1,000 crore company profit that there is a limbo.
Right.
There is no resolution happening.
Right.
So this was very challenging, right?
Very, very challenging. I mean, recently, INOX Wind. INOX Wind is a listed company. We were talking other day. I mean, the for a small creditor of, I don't know, I mean, 60 lakhs? 59 lakhs precisely. And it was established debt, operational creditor. Maybe he was writing and he sent a notice. Company did not take it seriously. It was filed, admitted. Listed company stack tanked 20-30% in one day. I mean, this is the magnitude. I mean, the way we'll have to take note of this very seriously.
The only missing point at INOX will maybe that they have not taken the notice seriously.
Ah.
They have not taken the application filed with NCLT seriously.
Right.
Then they went into this trouble.
This trouble, today you cannot reverse. You have to go through the insolvency process. You have to go through the resolution process. There is a cost attached, there is a time attached, and there is a, there is a nuisance value, there is interim resolution professional, financial creditor, maybe all your plans can get derailed.
So they have filed appeal with NCLT.
Ah.
And happy note that no opportunity has been given in NCLT, probably they will get some relief on that.
Ah.
Otherwise they have to go to the party wants to have an arbitration.
Ah.
The record has come.
Ah. There is no arbitration. After it is admitted, there cannot be any arbitration or a consent. But Supreme Court has in one matter decided favorably that there can be a consent. But whether it applies uniformly for all the cases or everybody has to knock the Supreme Court to get the consent, we'll have to see.
So in these cases, do you have to still go for valuation or not?
Yes,
I mean, just for 59 lakhs or 2,000 crore company.
you have to go. I mean, these are the things which we need to understand more.
Huge expense for the company.
Yeah, yeah. You settle before admission. You settle. Or amicable. Yeah. Yeah. Yes. Yes. Right. No, financial creditor is 1 lakh. No, thanks for clarifying. Huh? We all evolve, sir. I mean, all will evolve. I mean, maybe 1 lakh can go to 1. I mean, there is a benchmarking to paid up capital or turnover, which will come. Yeah. Yes. Right. Of the financial creditors. I mean, yeah. Okay. I'll cover now. I mean, as part of the resolution plan. I mean, so the whole outcome of the resolution insolvency is get the resolution plan. When we say resolution plan, I mean, it's a revival plan. How can you revive this company? What steps and decisions you can make so that this company gets revived? Whether the financial creditors will take a haircut, what kind of haircut they take it. Now you have some non-core assets you want to sell and bring you what is sustainable debt based on your cash flow. What all? You can do whatever comes to your mind, think possible that it can be implemented. You have to prove to the financial creditors, this is the resolution plan. Can be given by anybody. Promoter can give, company can give, financial creditors can give, operational creditors can give, but it has to be approved by 75% of the financial creditors. I mean, we are yet to see, resolution plans in the public domain. Last 1 month I have been working on it. I know I put my own mind and brain into this, and we are working on it. Maybe next 2 weeks, I mean, this company turns out to be quite, supportive, and the bank, we have 4 banks, we have been working very closely, and maybe next 2-3 weeks we may have COC approving the resolution plan and filing with the NCLT. Maybe this could become one of the first companies in India who have filed the resolution plan approved. Hopefully, the way today thinking is, it is likely to happen that way, but we don't know. If it happens, it's good.
Is it applicable to a person who is outside India, means foreigner or foreign company corporate? Means can an Indian put a insolvency petition on a person who is outside India?
This law doesn't deal with the person outside India. A creditor outside India against Indian company, it is covered. while the law says very briefly what it should contain, maybe we have to make it very, very comprehensive, maybe definition. This can become a charter, maybe 3-4 years. In the resolution plan, I mean, you can have it for 2 years, 3 years, 5 years. You have to prove that, how are you going to take care of the stakeholders and stakeholder claims, how this company will get revived, all that you have to demonstrate. So there is no tenure prescribed, but you can have maybe 2 to 5 years based on, company to company. There is a little bit of a misalignment. There is a misalignment of various stakeholders. One, now, there are friends from the NBFCs and banks here. They are financial creditors. Now, what are we saying? What is the objective of the insolvency? Insolvency objective is to revive. As a banker, secured or unsecured, I am sitting in the creditors committee. What is my interest? What is my interest? My interest is how do I get back this money on a yesterday basis. You are saying you wanted to revive this company. So there are misaligned interests. As a financial creditor, is already stressed, maybe has provided already some 10, 20, 30%. Now with the new RBI notification, maybe you have to provide 50%. So you are asking him to revive the company. Look at the revival of the company. It's going bouncers to the bankers. They have to again fund. So that this is a cultural shift and all of that. That is a major misalignment. Every creditors meeting, I am talking something, they are talking something. Is in a OTS, how much money I will get, when I will get, and all of that. But I think it may happen, something like that. The one scenario is a OTS. The other scenario, bankers are confident. Maybe you can bring in another investor. Maybe another customer can acquire and salvage. All that has to be done. But today, purely, people are looking this as another OTS. To quickly solve the problem. We'll have to see that.
So what happens if the corporate is not supporting you?
And you have to deal with it. You are a statutory body, you have powers. Wherever there is no support, you can go to the NCLT and get the direction, but every day, morning, evening, you can't go to NCLT and get the orders. So you have to do the balancing act. You also take the materiality, judgment and all of that and see what is, you don't get into a smaller things and all of that. No, we are not in that league. Maybe Big Fours would have. They are in a different league. Yeah, there are instances, right? There are some insolvency professionals who are not allowed. They went back to the NCLT, got the orders, took the police protection and support, and went ahead. We'll evolve. They're part of the game. Yeah, board gets suspended. Automatic. No, there's nothing. Board suspension, check power are the, are you saying once board suspends, automatically check power comes, or you should get check power? Then I have created a control mechanism. I don't sign the check. Below 1 lakh rupees, the senior management does. Above 1 lakh rupees, everything gets intimated to me. Yeah. If there is no money, this is what we need to understand. Say today every rupee expense is funded by a promoter. What is that I need to monitor today? Logical, right? Don't get into too much when there is no money. He is putting from one pocket, he is spending for salaries, electricity, PF. Taking check power and all that, additional headache, which has no meaning.
Order of preference is same like what?
Yeah, I am going to cover. Yeah. See, one question you raised, what you said was, if there is a dissenting financial creditor to a resolution plan, let me before that explain one concept, the waterfall mechanism. Waterfall mechanism is, in the case of a liquidation of the company, whatever money that is realized through the liquidation, how that would get distributed. Let me just go to that slide and come back. This one, yeah. Order of priority. The one big thing government has compromised is their priority. Versus, earlier under the new Old Companies Act, under the IBC, they have taken their priority with the unsecured creditors. Earlier, government dues used to be the first priority. Preferential payment used to be there. That is the one big change which has happened. Now, today under the IBC, this is the waterfall mechanism. Any money realized in the liquidation, it has to be used in this order. You first exhaust first, I mean the entire insolvency resolution process cost and liquidation cost, then the workman due for 24 months, and debt owed to a secured creditor in the event such secured creditor has relinquished security in the manner. I mean, either he can take his security, go after, or he can relinquish and get a priority here. Then the C, after the workmen and the secured creditors, wages to the employees. Then D, financial debt owed to unsecured creditors. Then any amount due to central government and state government, debts owed to a secured creditor for any amount unpaid. Then any remaining debts and a preference shareholder and equity shareholder. This is the water flow mechanism under the IBC in case of a liquidation. Now, what is the relevance of this water flow in the resolution plan? I mean, that's the question I had for a long time. Today, it looks like, I mean, I got answer on that. Now, what it says, in the resolution plan, if this company goes for liquidation, if operational creditor getting against 110 rupees, you can apply that formula in the resolution plan itself, while in the insolvency itself. What you could achieve through liquidation, you can achieve in the insolvency itself. Government doesn't get any money in the liquidation, don't pay. And if you want to pay, it's good. I mean, you put a resolution plan where you want to accommodate everybody, great. But what it provides, their liabilities will get extended, can get extinguished if they are not entitled in the liquidation. I mean, so this, I mean, for me also it took a lot of time, but it looks like that is how it is designed. You don't need to liquidate and go through a water flow mechanism. That same thing you can achieve in the resolution also. Yeah, it's central and state government. But again, another question. Now, provident fund contribution, the employer contribution and employee contribution. Whether these two have a different character or they can be the same character. Maybe if you have deducted from the employees and you are a trustee, you are supposed to pay that money. Versus, I mean, your obligation of whatever percentage. Your corporate tax could be different versus your TDS obligation. I mean, all of this, you know, we'll have to see, you know, maybe in the times to come. You know, the friend Sajit is here, he has some insight on this. Maybe he will share going forward. Then coming back to your question on the in case of a dissenting shareholders, dissenting financial creditor will be paid prior to the other financial creditors. I mean, that is very mathematical. I mean, I don't see a much gain there. As a financial creditors, collectively you get 50. You have a share of 10, right? In the resolution plan, if it is provided, you will get equally in that proportion. By just dissenting, you get your money, then you get balance gets disbursed. Doesn't mean that you get more than what you deserve. I mean, that's the clarity.
Trying to revive it, right? So whatever cash flows come in, you are trying to say that those cash flows should be accommodated for these particular ones. Is what you can do. So I can understand because you have a business plan, right? Under the business plan, you have to plan the fund. Right. If you don't do that, you will not be revived. Right. But if you are going to put this thing in plan, the plan is there, you will not be revived.
Yeah. So now we have 3-4 parameters or 3-4 numbers with us. One, we have the claims, and maybe we'll do a little small example. We have a claims, assuming claims are 1,000, which maybe 500 is from the financial creditors, 300 is from the operational creditors, 200 is from the government. 1,000 is the total claim constitutes. Today, the liquidation value, should this company goes into liquidation, how much I get? I have a value from the, based on the valuation. It says 200. It says 200. So you have a claims of 1,000, you have a liquidation value of 200. Should I put this company into liquidation, I'll get 200. Whole 200 goes to the financial creditors. So the same logic. Now when you do a resolution plan, either the banker is taking haircut or you are putting a fresh money, you can apply this waiver or extinguishment of liability is what it says. But we'll have to wait and watch what is the, I mean, how the operational creditor is going to take this, how the government is going to take this. I mean, we'll have to see few cases getting challenged and settled, then only we'll have confidence.
Considering all secured creditor at par, is it not a way, say I am a director in the company,
Right.
and I have given a 10 crore rupees of unsecured loan.
Right.
Now I know there is a 500 crore of other loans which company has taken from the bank.
Right.
I create some minor security for my loan.
Right.
I convert my unsecured loan to a secured loan based on a, say, a car.
Right, right, right.
Suddenly I step into the shoe of a secured creditor and have a share, pro rata share, as equal to the bank. So in such kind of cases, where promoters and shareholders will convert their loan from secured, unsecured to secured, and it's a very minimal security.
Yeah, I get I get what you're saying, but I don't know, by related party definition, whether this priority gets challenged. In the COC, I mean, you are not there, but in the distribution, whether the related party is getting excluded in a, in a priority is what is the question.
Yeah.
It is not, looks like.
Right. So this is coming as a way out where directors can suck in money even at the time of liquidation.
Yeah, maybe, looks like there may be some gateway. Yeah, I mean, this is what we discussed, resolution plan. I mean, the 180 days plus 90 days, and the order of the NCLT becomes the effective date for the closure, and moratorium ceases from that date. Either the resolution plan does not get approved either in 180 days or extended period, or it gets implemented in contravention and somebody challenges that it has not been implemented, then this company going to go for a liquidation. I mean, it looks like very, very harsh. I mean, solvency test, while we talk about 1 lakh rupees, there could be a temporary stress on the financials, but I mean, it may so happen that 270 days you are not able to put a resolution plan. And it can go for a liquidation. I mean, the market has to improve, I mean, in the sense, some of these assets become attractive at some price. Now, yesterday, Tata Sons openly, Tata Sons or Tata Steel openly said, we are looking at some of these assets which are in the insolvency process. Companies running very well, stress is high, leverage is high, but maybe they make sense at 0.5x of what it is today. Maybe I want to bid. But it may not be the case with all the companies in terms of transparency, how much you know, how much you don't know, all of that. This is the time chart, from application filing to, 180 days. Very, very, every step there is a time-bound program. And sometimes we are not able to meet. You need to publish public notice in 2 days, while the NCLT order is coming after 3 days, 1 week, 10 days. I mean, there are some of the teething issues. This we looked at the order of priority. I mean, so as we speak today, 160 plus companies have been admitted. Maybe more than 100 companies or 100 applications have been rejected. Now, substantially, the majority of applications are from the corporate debtors and financial creditors. Operational creditor applications are very, very low. But it is not that even for somebody want to make an application, there is a pros and cons. There are pros and cons. Even for the company, there are pros and cons. It is not simple, I'll make the application, I will be beneficiary. As an operational creditor, if I trigger insolvency, if during the admission, if my amount gets paid, wonderful, as an operational creditor. But if it is not paid, there's a cost for you. Obviously, you have to hire somebody, you have to pay for the public notice and all of that. Once it is admitted, if the company is very strong, they don't want to, they get through a resolution plan, there is no waiver, the liquidation value is much more than the claims and all that, he will get the money. Otherwise, neither he has a say, nor we don't know whether he will get his money or not. So, if it is company strong, is unreasonably delaying the payments, then it can work as a weapon. But otherwise, he doesn't get anything. Only thing he will have further costs.
is only to initiate the action. As soon as I initiated and the case is admitted,
Right.
then there is no cost for me as a litigant.
As a litigant, operational case, as an applicant, there are 2-3 costs which are coming to you. One cost is the, obviously, I mean, the representation is the one piece. The second piece is, for a public notice, you have to fund. As an applicant, you have to fund. And then third, the, I mean, resolution professional. Company doesn't have money.
No, irrespective.
Right.
The moment it is appointed, it is company's obligation. If at all there is a liquidation, 1 rupee will come out of
Right.
it. It will go to the professional.
Right.
So, being a 1 lakh rupee operational creditor,
Ah.
if I want to harass the company,
Right.
coming to this point that it will become a nuisance value,
Ah.
I can hire a lawyer who can draft a petition and file it
Right.
for a very minimal amount.
Right.
And then do a paper publication on 2 newspapers. We all know what the cost is.
Right.
So technically there is no cost for me.
I mean, yeah, so I mean, that depends on the case to case. If you are going after a big company, maybe you spend less money or more money, still you may get some salvage, but you are going for a, the small company where there are no cash flows. If you want me to act as a resolution professional, I want funding to be in place. Today I don't have funding in place. The company doesn't have money. Financial creditors don't support. There is no mechanism today. I mean, while it has a priority, but somebody has to fund today. In my own case today, I am going here and there begging, borrowing, but I need these costs. I need a valuer to be paid. Where do I get this money? Maybe it has gone to such an extent, I had to fund. Now I am figuring out how do I get back. Forget about my fees. I mean, so I will get settled. I mean, so.
But we had one point that resolution professional, the operator need not recommend.
Ah.
So the cost is less for him.
No, it need not be recommended, but somebody has to pay, right? Company receipts, company doesn't have money. Right.
You're getting an IRP. Okay, you have to be funded. You have to be, the payment has to be made, right? So this has to be tackled with the statute itself. Correct.
And the idea is, I mean, level, they say, you can get the financing. I can go and get the financing for this expense. But if it's a smaller amount, who will come? Maybe it's a big ticket amount. Maybe the NBFC will start. Instead of lending at 11%, I lend at 18, 24%, which is secured. You will get a priority. If the resolution plan is an exposure is 1,000, 2,000 crores, why not? Maybe you guys should look at this line of credit.
In the situation, most of these companies are bankrupt, almost bankrupt companies, and you go to have 1 lakh to 10 lakh kind of credit, operation creditors or financial creditors, then if you don't have professional, if you don't have these pieces of professionals,
Right.
would go for such things.
Right.
I mean, at the end of the day, it's like vicious cycle.
Right.
Raghu,
Ah.
you have to get a separate training from Big Four.
Ah.
How you get this?
Right. Please go ahead, no problem. Right. 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 Right.
Now after a few months, that is maybe or
Yeah.
maybe before 6 months or after the moratorium period, I have recognized that the thing is this particular publication has already been done.
Right.
And feels that my lot of money has been blocked.
Right.
And how can I do that? How can I trigger the IRP application?
Then I mean, see, within the period where the claims were called for, if you have done it, it's fine. But even before the resolution plan, if you are able to prove, maybe you have to go to NCLT and take the permission. Now, entire my distribution is based on the claim versus the liquidation value. So, if it's already resolution plan is approved, I don't think you will be able to claim back. But before that, maybe, making application to NCLT, maybe your claim can be admitted. Right. Right. Yeah. The idea is once you have an information utility, some of these, issues gets resolved. Right. Right.
To add to that, operational creditor actually is unsecured creditor.
Ah.
chance of getting any money liquidation is,
Ah.
I think it's rare.
Ah.
But of course, the system will be there.
Right, right. I mean, there are various cases, in 160, there are a lot of, almost 100 have been rejected. I'm not getting into the details, but there are classic cases where employee going after his previous employer, and that got admitted as an operational creditor, that company is under the CIRP. Now some of the customers of a real estate company, for the advances they have paid, where the employer has not delivered and the company has not delivered, so they went, but the NCLT said this is not a debt. That doesn't come under the purview of the IBC. Yeah, 160 companies have been admitted so far, and this 17th January 2017 was the first company which got admitted, Innovative Industries, filed by the ICICI Bank. Now they have also got the extension. The key thing is, we will have to look at each role play in each company and see, how is that impact. If the company, if my customer is going insolvent, if money has to come to me, what is my role? How do I protect? Similarly, my supplier is going into insolvency. I am going into insolvency. What is going to happen? Very, very important thing which governments have not realized yet is their claims getting waived in the liquidation process and the resolution process. How each state governments and revenue departments will behave, we need to understand. Yeah? This definitely opens a lot of opportunities to the professionals, either the insolvency professionals or the valuers or the representation before the regulators. A lot of other associated services. Now the banks are looking at the management takeovers. The biggest challenge today, banks own 99%, promoter own 1%, but he still drives, given he knows the business. But banks have no option because they are not in a position to take over. Maybe they may start take over. The Edelweiss is largest ARC started acquiring the loan portfolio and the management. There's a defense company in Pune. They have acquired the management. Triggered the insolvency. Already creditor is in control. You put your management. Take it. And it may happen the promoter, equity may get extinguished, or you become very, very insignificant. You convert your debt into partly equity, all of that. Thank you so much for your hearing and very, very active participation. So we have a panel discussion, maybe 20-30 minutes, and then we can. That's how we have planned the program. Thank you so much. Yeah.
Thank you, Raghu sir, for the very enriching session on the insolvency and bankruptcy. I think all of us here have a much better understanding now on the subject. So we are now ready for the panel discussions. I'll just introduce the respected panelists for the discussion. Mr. Sajid Walapila-Kandi, he is a partner in India Law. Mr. Sajid has close to 2 decades of experience in legal field, particularly in telecommunication law, security laws, exchange control regulations, data privacy, technology, and litigation. Prior to joining the law firm, he was associated with various reputed companies like Reliance, Airtel as their in-house legal counsel. We welcome you here, sir. Our next panelist is Mr. Parvesh, Head Legal EPC and Solar in Lanco Group. Parvesh is a qualified company secretary and a law graduate from Delhi University. He is a seasoned solar power and infrastructure industry counsel with an experience of over 15 years. In his career, he has also dealt with international litigation and has exposure of setting up entities at various overseas jurisdictions. Welcome, Parvesh. Mr. Raghu Babu, mentor and advisor, Samishti.
Good evening, friends. Let's make this panel discussion Q&A very, very active. Questions where you think, some of us would have answer, and questions none of us would have an answer. Let's discuss. And I want to thank Parvesh for coming all the way from Delhi, and then he has been telling that we should do a session on through, under the banner of AOCS for last 2 years, and today we have been able to do it. I want to thank him for coming all the way, and he is going to kind of lead the panel discussion. I want him to share. I mean, you all know Lanco is one of the 12 companies which have been directed by RBI to, trigger the insolvency. I want him to talk about, maybe 5 minutes, and chair the panel, and then also want Sajid to share few minutes, his thoughts, and then, floor will be open for discussion.
Thanks, Raghu. In fact, I will restrict myself to comment anything on Lanco's proceedings because my internal code of conduct doesn't allow me to deliberate on that issue. But certainly, I will share my experience on those issues. And starting with, though I have given a brief introduction of our course earlier, that we are conducting programs. In March, we had our third annual meet in Gurgaon. There we introduced that we are forming few committees. Raghu has raised the point that because IBC is a new concept in India and we all are learning on IBC, there are few other GST and other laws are there where lot of clarifications are required from government. So we have incorporated, formed few committees under ECOS, under our platform, where we are representing government, we are giving our suggestions to government, so that we can get answer, we can represent the community, legal community, company secretaries and in-house counsels. Recently we are discussing that in the last meeting we discussed on arbitration, that lot of arbitrations are going on, so we are suggesting government to have a online arbitration as well, no need to have the physical arbitrations. So there should be concept of online arbitration authenticated by the government, so early resolution will be there. You have seen in this scenario of online e-commerce, so we are buying products where we don't know the seller also, so in those cases online arbitration is possible. So coming to IBC, so we can certainly approach government on the issues which are undecided, which are not clear, and take suggestion from all the legal community and represent to the government on that community. So IBC, no doubt, we have learned two of our speakers, Prashant and Raghu, and detailed presentation. It was a nice presentation, and though most of the things are clear and all basic things are clear, and we could understand the practical experience also, how he is dealing in the company as a resolution professional. But what is the intent of government on IBC? I understand that government has come with a intent or with a motive to bring our corporate community, corporate house, Indian INC, to bring at a stage where the business is going in a free flow basis. Like if the company is not performing well, and government should not support that company, or bankers should not support that company to continue in the same manner. Like we have seen the cases where the company's bank accounts are NPAs, and still bankers are supporting those companies, giving some source of funding, and that funding is used just to pay their interest only, nothing more than that. So those funds are never going to the project, but that is going to the payback to the bankers, so bankers can save their NPAs in their books. So the intent of government may be, let's come out with a free flow of business. If the company is not performing well, let the company not go with that business. If the promoters are not performing well, let us give a chance to other promoters to take over the company and do well in that business. So I was just reading two lines of Insolvency and Bankruptcy Code, which the first paragraph of that code says, an act to consolidate and amend the law relating to the reorganization, insolvency, resolution of a corporate person, partnership, individual, in a time-bound manner. That is one, they are looking for a time-bound manner for maximizing the value of assets of such person, to promote entrepreneurship, that is another intent of government, availability of credit and balance of interest of all stakeholders. So I think the government moved, the NDA government moved from the day one to ease of doing business in India. That is a one step towards the ease of doing business of India. The other may be like implementing the GST, coming amendment with the Arbitration Act, so few others. So these are few steps where government is looking forward to give the comfort to the foreign partners, like we have seen in the presentation, recoverability of liquidation time frame, recoverability of value under liquidation, that all will resolve those issues which a foreign funders sees the complication while investing in India. So government came with IBC that has come in 2016, December 2016, with all those intent we have, which I just addressed. So then government found that from the banker side, bankers are not so happy to go for the IBC against the companies. So we have seen that under few of the companies like Innovative, ICSA, Bankers, but the big companies, bankers have never initiated the insolvency and bankruptcy proceedings against the companies. Then government tried to push the bankers for the same. Then they came with the ordinance giving the power to RBI, that RBI can give further mandate to bankers to initiate the insolvency resolution proceedings against the company. Under that mandate, RBI constituted a committee, which committee formed some criteria that which company needs to be referred to NCLT under insolvency resolution process. So they came with the criteria, the companies with 5,000 crores of debt as on 31st March 2016, and out of that 60% of the debt is NPA, those companies will be referred to NCLT for insolvency and insolvency resolution process. That we are one among them. So there are 12 companies which are being referred by the bankers to NCLT. So I understand till this time most of the companies have already been referred, and in few of the companies resolution profession has already been appointed. So most of the big companies, big fours, are getting that assignment of resolution profession in those companies. So now that government is planning how those companies can be revived. If not, then liquidate those companies. Revival may be any of the resolution plan for those companies. Either it will be new promoters to come in and take over the companies and to run the companies in a better way, or the Raghu told that bankers may take their own control, and bankers will take initially control and then further sell it to someone else as a new promoter, or they may come with a resolution plan that the existing promoters who have their expertise in the business, in discussion with them, they may come for some resolution plan so that the company can move. So if the company cannot move, let's close it. That may be the intent of government. So if the company is a good future, let the creditor decide, not the debtor. So another move in this IBC is there is no say of debtors. So everything has gone to creditors. Creditors have their own role to play. Like resolution professional has to constitute a committee of creditors, and committee of creditors is only the bankers, mainly financial creditors. Like one point has been raised, if there are no financial creditors, then operational creditor with a maximum number of 18 can form that operational creditor committee, and they will come with a resolution plan. So under that resolution plan, few of the practical issues which has already been covered, like maybe repetition, but I will try to avoid repetition. Few of the practical issues which has been dealt during this 6 months by the few NCLTs or NCLATs. One issue we have seen that timelines has been given in this complete process, like demand notice has to be given by the operational creditor, that demand notice has to be replied by him within 10 days. So that 10 days is a fixed period given under that. Then if they don't reply in 10 days, or if they reply with a dispute and or the payment to that debt, then the other party goes to NCLT, and NCLT has to decide within 14 days. This 14 days was a question earlier, like whether this 14 days is a mandatory, and few of the companies has gone to NCLT, the petition against which has not been decided by NCLT within 14 days. So they have taken a plea that 14 days has already over and NCLT has not decided it. So the application has become infectious. So there should not be further proceeding on those applications because 40 days are over. So NCLT has decided in that case that these 14 days are only procedural. They have taken all other time fixed under the IBC are mandatory, but 14 days is procedural time. NCLT can take more than 14 days. As Raghu told, in fact, in Hyderabad, the time taken by the NCLT is more than 2 months. We have seen few cases where around 2 months has already over, then the things has not been yet decided by the NCLT, Hyderabad, and in few other NCLTs also. There is no amendment to the act. NCLT has given clarification. By judgment, that clarification has come that it's a procedural. So that is.
The judicial discretion is always used for discrimination.
Yeah. So that's what happened here. Yeah. So other issue was dispute. What the dispute is, because your IBC says if the operation creditor send the dispute notice to the debtor, so he has to reply within 10 days and says that he has to reply raising the dispute. And what does the mean of dispute? Any suit or arbitration and proceed going on against the company. So initially the view taken, what does the mean of dispute? It is only suit or arbitration is a dispute, or it is more than that? So that issue has been decided by various NCLTs in a different way. Delhi decided that dispute does not mean only the suit or arbitration. Mumbai decided it is only mean that there should be suit or arbitration. But deciding that it is only suit or arbitration is not logical. Like suppose I am a company and you are the supplier to me, and you have done one work for me, and or supplied something, and I have there are some discrepancies on those supplies or default in that supply. If I raise those issues with you, you approach NCLT that my payment is due, he is not paying. So there was no chance with me to raise those disputes. And you are the person who is claiming money, and 90% chances that you will go against the company to raise the dispute that I am not paying you the money. So that issue has already been decided by NCLT. They told dispute does not only mean suit or arbitration, it is more than that. So I was attending that hearing in the NCLT when the arguments were going on. So they told that dispute may be more than that. It may be akin to some suits or proceedings or arbitration going on, or some other evidence are there that the parties are under discussion or there are disputes with the other party. So generally they told that dispute should not be after the date of sending the demand notice. So I think I will request Sajid also to give some thoughts on that later, that how to take care of the dispute if genuinely there are dispute and you are not raised with the company. So how to take care of that? How corporate companies can plan accordingly so that they will not be harassed by the others, because it's a big harassment in the industry. So one point came in between where someone has raised the issue that how to how to get out from this issue if being a 2,000 crore companies. We have taken the example of Inox Wind. Even yesterday I was discussing with the CEO of Inox Wind on this aspect only. They are positive that they will get some positive judgment from NCLT, yet to be decided, arguments are over. So how to get out from those harassment? So one, I can say that we should be very careful on the notices received. We should not be taken it lightly, because being a new act, things are getting evolved and getting decided by the various NCLTs and NCLTs. So we should be careful on that. And yes, there are harassments in the system. So how to get out from the harassment? So probably Sajid will enlighten on those issues. And so Sajid, like coming on this, what are going in the industry, that so many companies are being admitted under NCLT, and few of the companies are not, like we will say, not deserve to be admitted there. Like they are a big company, good company, but someone with 59 lakhs or those has taken them to NCLT. And this tool is being used, I will say that misused in the industry also. What is your thought on this? And how we have to take care of that?
Small word. It is abused.
Yeah, right.
Already. See, our laws never failed. Where we failed is the infrastructure and the manpower. You take any laws, this country has a great laws. No law ever failed. It was legislated with a correct intention. It was put in the right perspective, amended at the right time, but infrastructure failed. Take court. We have the old court, same number of judges. There is a pressure. Anybody from judicial background, pardon me, a judge gets same amount of money whether he settles a 1,000 crore case or a 100 crore case. There is no reward and recognition. That is where the laxity starts in the system. He has to sit whole day and the whole public is looking at him. Then he has to have all the emotional trauma which he comes from his home, whether his wife is fought against him or he fought against his wife. All these thing happens in a court. They are also human beings, number one. Number two, having spent a lot of time in corporate, I will tell, as a part of a compliance, please treat Section 9 notice very, very seriously. Triggering of insolvency is a one-way street. There is no return back. Once it is admitted, once creditors committee is formed, you cannot settle with that operational creditor and get out. Others may or may not permit, but you are into serious trouble, especially reputation. If you have a secondary way how to insulate this risk, In GRC, we all speak about insulating the risk. How to insulate the risk? In all of the invoices, in all of the demands you raise, you put a rider. Dispute, if any, should be raised on between so and so dates. No dispute shall be entertained here and after, especially under IBC code or whatever. That's only rider you can take. No, I'm talking, I give you goods and services. You don't pay me. So when I raise my invoice, I clearly say that. Yeah. I am the service provider or provided goods. Then I will say this is it. Now, resolution plan. Resolution plan, I have seen a couple of resolution plans, which is almost live presentations. But resolution plan should be actually like the, what you call, rehabilitation scheme of erstwhile BIFR. This is nothing, an extended arm of BIFR, and resolution plans also should be on that terms, telling who is to do what and what point of time. Then it is easy for a financial creditor or Section 7 or Section 10 petition to get admitted. It is very difficult to get a Section 9 petition admitted. It depends on a lot of courtcraft, and it depends whether it is Salve or Sajid going there. It depends on a lot of courtcraft. Convincing a judge what this NCLT may do or may not do is not applicable on the other one, Bangalore or Chennai bench. They have their own thought process. I was the first person who filed application under Section 7. It was very, very tough. Really painful, because I cannot blame anybody, because I am confused. The judge is more confusing me, and the public is also confusing me. But over a period of time, right now I find that if I file it, day before yesterday we have filed something, today it is coming for hearing. System has also caught up. So these are men with their own thought process and their own interpretation. Second is the powers of adjudicating authority, other than NCLT, Tribunal. Adjudicating authority is very vast under Section 65. They can take any matter for priority, number one. Number two, NCLT is only one institution other than High Court who can initiate suo motu contempt. So yesterday also there was an issue, I'm not naming the banker. He simply told, ask the chairman to come. So other than you can't talk law, then beg, bleed, borrow. That's the way they look at things. And other than industry, I don't think tribunals have taken this very seriously. I think you have the experience also, right? Bankers, they have their own problems, except ICICI Bank, nobody has a settlement policy in place. All bankers will have a OTS, they have a policy. JLF, they have a policy. Corrective Action Plan banks has a policy, but policy is yet to evolve on what to do with IBC resolution process, how much we can take. Today we are applying the principles, what is the liquidation value and how we are going to take, right? So this is yet to evolve. All laws are like avatars. It has its own utility, after that fade away. And another avatar comes in same way. Now to resolve insolvency, bankruptcy code is there. This code is very young, and code has got lot of interpretational values. It will get evolved over a period of next 5 to 6 years.
Yes, certainly it will take some time that this code will become a full-fledged chapter that we can work on that. So it will take some 4 or 5 years, in fact, to settle down. And coming back that when the RBI has given this notification, so those 12 companies, I understand all those 12 companies are going to be admitted, like few companies are yet to be admitted by NCLT. And one of the company, SR Steel, is trying to get out from that process, but they are working hard, but they are not able to do that. Like as Prashant told, they have tried to get stay from High Court of Gujarat, but they could manage it to get for few days, but finally the High Court of Gujarat dismissed their petition. Now that has been filed with the NCLT, so there also they have taken some objection. And yeah. So for others, I think Bhushan Steel they have already appointed, Bhushan Power they have already appointed. So yeah. So we will see. I understand these 12 companies probably will be a case study for all of us. Like it will be a case study for the further new companies, and even it will be the subjects of the for the some few of the courses also. So when the application is admitted, so Sajid suggested that we should take Section 9 notice seriously, and we should not take it lightly so that if admitted, we cannot go out. So, and we have seen the companies, so the suggestion comes from Sajid's side that like if we have dispute with the parties, so we should not wait for raising that dispute. We should raise the dispute immediately. Like waiting for the dispute and he has gone to NCLT, then it will be a trouble for us. Like there is a genuine dispute and you have not raised that dispute and NCLT will take it a afterthought till the time you are able to prove it and to justify it. No, it's a dispute prior to that notice. We have seen few cases where NCLT has taken different view. In some of the cases, dispute raised after the demand notice, they have accepted that yes, there is a dispute. In few cases, they told no, it's a afterthought, we will not take it, you have to raise this dispute prior to that demand notice only. So, accepting of application by NCLT, then the moratorium will start. Section 14 says they will start the moratorium. So, moratorium says there will be no, it prohibits the initiations of the proceeding and continuation of the existing proceeding. So, I understand that existing proceedings against the company will be prohibited, but company can initiate and those proceedings initiated by the company will continue.
Yes, the wording says against its properties. SARFAESI action will continue on personal properties, 110%. The wording is very clear, its property. That means any collateral offered by the company, its property, moratorium. Otherwise, guarantors given, it will proceed. They can recover. Here, insolvency, we are not trying to recover. We are trying to resolve. There in DRT, we are trying to recover. That's a fundamental difference between both institutions. That institution is only recovery. This institution is resolution, resolving. If not resolving, then put it to death.
They were trying to resist because one of the reasons was that we are reviving the company, the prices are becoming better, so why should we go for NCLT? Right? Now, why this resistance when you are already almost insolvent and the insolvency process, as Raghu said, is for the purpose of reviving it, then why so much resistance? The control goes from the...
You lose your control. Your board is suspended. You're putting yourself in the mercy of the lenders.
That's a big thing. The point number 2 was that they went to the High Court, right? When it is very clear that you have to go to the NCLT. Why that happened?
Sir, jurisdiction of the High Court is still not excluded. Whatever fundamental rights you are available, that right you can exercise there only. But so far as IBC court is concerned, you cannot take this matter there. That's it. Again, it is court craft. It depends from Hari Salve to Sajid, how you use court craft to get your case admitted.
So typically what would happen after that a couple of months, or maybe a year or 2 years, when it is not getting solved at the NCLT level, then can nothing go to the High Court?
No, the outcome of this is either resolution or liquidation. There is no middle path. Or appeal.
Yeah, even in appeal till the time you get some order that your process will continue, that resolution process will continue. There is no, if no stay is granted, then resolution professional will continue with his proceedings. He has a limited time frame of 30 plus, total 180 plus 90.
In Nath's case, he might be doing his work.
He must have started his work, yeah. Perfect, yeah.
If the company has defaulting data, whether the NCLT has power to enforce them?
Obviously. It's an institution which can initiate contempt suo motu. And we all know the procedure.
During the insolvency process, whether they will look at that, if there are defaulting data, they will
It depends. If the chairman of the creditors committee go and take it up, obviously NCLT pass appropriate orders, subject to satisfy the court.
So under moratorium, we were discussing that cases filed by the company, that will continue.
Yes.
There is no moratorium on that right now. So Raghu, just one thing, like you are dealing with
no action shall be initiated
against the company, yeah. So there was a discussion earlier because now it clarified that no action shall be taken against the company. So whatever cases or arbitrations has been initiated by the company, that will continue. So Raghu, just one point, because you are doing resolution process of one of the company. So being a professional, resolution professional, there are so many things to do, to revive, to understand, to make it a going concern basis. So you find that company needs to initiate some legal action or some criminal actions against third party. Will you suggest them to do that? Because you have to sign those, you have to authorize those action in the company. What is your thought on that?
I mean, this particular case, we initially wrote to the customers. There are a lot of debtors which are outstanding. Idea was maybe if there are genuine debts where you can recover some money, maybe you put back into the company and revive. But we have written to almost 10 12 customers. There are various issues there. That's, work is not complete. There are quality issues. There are customers are, going through the difficult times. So then we have not initiated the further recovery process. Yeah, and the biggest challenge today I see, creditors committee, the way they think, the way they behave, I have to change. Today, still I am thinking I am a banker, I have to get this money, that's all. But the way it is articulated is you are in control, it's your baby. I mean, how do we change? Whether this will ever get changed is a big question. I mean, that is another big question. Whether, I mean, who is authorized to attend the committees, who is authorized to present, I mean, whether they have enough powers. And I've been asking authorization letters. In one bank, lead bank, the zonal manager is personally involved. He is attending. But otherwise, they don't have a policy as of now. The same recovery branches are handling. They are also equally new. We had transfers issues. Again, things got derailed. Now only the committee got stabilized. So, it's a challenge that the creditors thinking that, the way they need to look at this differently is a biggest issue. It may have to undergo change, or I don't think they will ever change. Why? What is their incentive? To think about the company. My incentive is, to get back my money. I am short term.
So just like Sajid has said, unless the top management gives weight, otherwise middle management has no leadership.
Yeah.
They are saying for 30 years.
Yes.
So middle management of banks, if they come to you, please forget the IRP provision.
I want to add here.
So, but one thing, bankers are also very serious. It is not that they know it is not earlier DRT process. I am also very clear. If you don't act on time, the judge says, I will not beg pardon for you. I will not bend my spine. Most of us practicing there are very clear in this matter. So bankers also get queries because RBI is behind these banks. So bank board itself is very, very sensitive. Earlier when we used to file DRT, nobody bothers. Just like Bajaj scooter, fill it, shut it, forget it. So he'll put it on my table, go it, number, it goes. But here I find a difference is almost bankers, I'm almost involved with 8-9 bankers. They are following up. क्या हो रहा है, कैसा हुआ, आज क्या हुआ? That too from their head office. This matter, because they are putting all the mota matters right now. And difficulty is, what can this have can this code have a consequence in Malaysia? Non name basis I will share. An Indian company took loan from X bank, and another bank outside India in Malaysia was given a corporate guarantee for this bank, this loan which is being extended. That company went into trouble. Now Malaysian bourse, it is registered in Malaysia. They are threatening Malaysians, telling that we will initiate corporate insolvency in your country for your guarantee which is given. So the repercussions in DRT, we don't have such kind of repercussions. But another foreign corporate guarantee is being given, it can get invoked. So this actually go beyond our borders.
Yes, some question.
Voluntarily declaring insolvency is covered.
Yeah, voluntary. Section 10, like 7, 9 and 10, there are 3 sections. So section 7 says for the bringing the company to NCLT by financial creditor. Section 9 is by operation creditor. Section 10 is by the voluntary admitting themselves to be insolvent and approaching NCLT for resolution process. So,
when you go for voluntary section 10, it is one single shot stay. Instead of going and DRT getting one stay, my 138 getting harassing me, even 130 gets stayed if the instrument is issued by the company. The directors are only representative of the company. So instead of going to multiple functionaries or multiple bodies, go to NCLT, file it there, at least for 6 months I will have patience. बाद में देखेंगे. Or I will again plead, beg, borrow for 90 more days. 270 days I can have a peaceful sleep. When the action against the company is being, moratorium is declared, then what happens? The director has signed the check for on behalf of the company. So moratorium is the company. Consequential thing is that 130 will get stayed.
Courts also will take a lighter view. I mean, you can state this.
After this, whether the business of ARC will get come down?
No, ARC will better for them.
Yes, it doesn't do it. Earlier, bankers were selling off the distressed assets to ARCs because they want to get into the business. But in the bankruptcy code, they can get into the business. So whether they will want to get into the business or they will want to sell off to ARCs.
No, IRPs can approach ARCs also to get a good valuation.
Yes, works becomes better now. With this process, it becomes better for them.
Is there any limit for a company like the company is revived by the this IBC coming out and again going for insolvency? Is there any limit?
1 year. 1 year you cannot go.
Okay, 1 year.
Because you will not go also because the resolution plan itself will be over 2, 3, 4 years, depending on what kind of structuring, financial structuring you have made and at what times this become triggered. So 1 year up sochege nahi, 3 years, 4 years. I think going ahead, large companies, the structuring will be for 10 years. This all required because BIFR failed. A matter filed in 2003 in BIFR, get this DS rehabilitation scheme get passed in 2016. What is the point? By the time my steel would have become rust and rust would have become mud.
Some people are seeking 20 years package actually.
Yeah, even in BIFR, people were on the BIFR and for years. Detail, but winding, in fact, the concept of winding up is out now. Like there is no winding up proceedings against the company. Other concept of winding under IBC. IBC code says that finding the resolution process of the company. So the intent of government is let's not close the company on the day one. Earlier, if you are not paying money, so that you approach to the High Court is satisfied that you are not paying money, let's close it. So closure is not the concept. So if the funds are put in the company, public money is involved, let's try to find solution and let's spend 6 months to 9 months to find that solution. If genuinely we cannot find solution in these 6 months to 9 months, then close it. So that is another intent of the company. But I am not I am unable to understand that why two parallel processes are continuing. High courts are typically taking so much time. So those petitions are still pending with the High Court before 15 December 16. So that may come any day, and the same concept may come that can be closed on the day one. So giving that time frame of the IBC, like they're transferring the things to IBC. Why don't they transfer the initial winding of petitions? Otherwise, court has taken already 3 years. Next, they are going to take 3 years. That will not be.
Sir, justice hurried is justice buried. Justice delayed is justice denied. So they may be thinking in that manner. Ideally, what I am being made to understand, off the record, what I told, what I am being told is, they don't want to push all these things unless the second court comes. Because it's already piled up. Piled up, we can see the stress on the infrastructure. An order comes, we cannot complain also. After all, they are also human beings. We can go and complain, judge will again shout at the bench.
In two court cases, there is a different opinion there. In case of Deccan Chronicle, there are cases pending against the company in the High Court actually, winding up cases. So the question is whether moratorium is applicable for them, those cases also. In case of Era Infra, what happened? He reserved the case. The Deccan Chronicle, the judge has ordered that he admitted the case. So there is a difference of opinion there. Whether this moratorium is applicable for High Court winding up case also.
So my understanding is moratorium should apply on this winding up cases also. But otherwise, there is no logic to go for the resolution process.
Up to Supreme Court. It does not discriminate court to court.
Right.
Any court, any proceeding. So up to highest court of the country.
If a company is insolvent and asking the directors of more if they want to start another company. So how will they can do the same type of business or some other?
Sir, your credibility is affected ना. एक बार चोर का चापा आ गया, आप कितना भी सत्यवान हो.
चोर बोल रहे क्या? ये तो mindset change होना है.
No, certainly, like, see, insolvency, if we look at on the international perspective also, insolvency is a prevalent term in other countries. Like, genuinely, if you are not able to do something, you are not able to work, you have to declare yourself insolvent. Like, then you have to restart yourself. So there should not be ban of restarting. So if I have started one business, I cannot continue due to any reason, genuine reason. So I should not be penalized that my decisions were wrong. So if it was a cumulative decision, bankers have funded me, it was their decision, provided there is no siphoning of fund, intentional fraud in the case. Otherwise, it's a chance should be given to all. So you are bankrupt now, company is bankrupt now, promoters can start their own business. He's right that then it will be difficult on you to prove your credibility that you are going to do a big business. But that can happen. There is no bar on that.
Most of the companies which in trouble now, it is bankers making only. Outside this room, I will deny what I told. The reason is, when it comes as SM1, SM0, SM1, SM2. Then it is provisioned as non-performing asset, substandard asset, doubtful asset, write-off. That is the process which RBI has insisted on the banks. So no banker sitting in a branch wants his account to be NPA. So what they will do is they will arrange some other collateral, they cover up. The guy actually needs working capital. He actually needs ILC or line of credit or letter of credit. That never comes.
That is the main problem, in fact, in the system. That is
in consortium banking, what you will find is, uska ILC leke isko dega, iska leke usko dega. So bankers' money is getting revolved. Yeah, consortium, sometimes what happens is multiple banking, not consortium. ये बैंक को जाके इसका पैसे देगा, इसका ILC लेके उसको देगा. So he will keep on putting some money. He'll take home also.
The fundamentals in Indian corporates, our promoters don't have the equity, which has resulted in this type of NPAs. Our equity is less, and our project costs are boosted up. As a result, today if you go to this 6 lakh crores of NPAs, the net haircut has to be there by all the bankers. They have funded most of it. It's all closed door. There's no journalists here. It's a live class. I say, okay, doesn't matter. I don't mind. So what I'm saying is, the basic problem here in India is that equity is brought in. If your project is about 1,000 crores, the promoter is supposed to bring in 300 crores. 70-30 debt equity well accepted by all the bankers or all the funding. So then what happens is, project cost is given at 1,300, 1,400 crores, and the equity is built up without a proper equity from the promoter. So this is the major reason for today's situation. And then now, how do you come out of this? The top bank management is a good way of coming out, because this vigilance code, all that has been done away with. I think I'm not very thorough with the bank, but since 6 months, they are allowed to convert loan into equity. They have been allowed to take the haircut. So no banker will lose this opportunity now, because haircuts are the only solution to it.
Correct, Anand, because there is a judicial stamp on the resolution plan. So nobody will go up to that, they can come. Beyond that, nobody can look.
Even if you want to take over, there is no takeover.
Because an action taken on good faith by a court. So NCLT also, adjudicating authority also has vast discretion whether to accept or reject or modify. It's not that they simply take it. And IRP has a very crucial role in handholding the financial creditor as well as the management, which I think is not that.
The solution can be a haircut, and then if necessary, professional management.
haircut will certainly be there. Like so these are the few things like haircut. Certainly, I understand in most of the cases, in all the cases, haircut will be there. And though the mandate says that they have to make provision of 50% on the day one of referring the company to NCLT. So bankers should be ready for the same, number one. Sajid says it's a statute, like they have that purview under the IBC. NCLT is authenticated. So tomorrow they will not be questioned on that. That is two. Third, the mindset needs to be changed, like either of promoter or of bankers. Like now the time has gone where like they are running the things for few years without having any value addition. So let's decide in 6 months and come out with the things if possible, otherwise go to liquidation. So that's great. And any other questions? Though there are so many things to discuss.
NCLT needs to have upheld the principles of natural justice. For some time back we covered on the notice part, where we were talking about ICICI Bank and all. I think one of the clients, Starlight versus ICICI. I think NCLT has specifically directed that principles of natural justice was not followed in one of the cases.
Yeah, so in fact NCLT has decided it that the principle of natural justice, compensation, cost,
penalty on the bank.
cost on the, in one of the case ICICI, I think I have seen in the presentation that 20,000 cost has been put on the ICICI Bank, but some amount. But the opportunity of being heard, natural justice, NCLT has decided that in few cases we have seen in the financial creditor case, the act is silent on that whether the notice has to be served or they have to be, the notice has to be given by the NCLT or not. So they are, that has been clarified. In fact, innovative case that has been clarified that opportunity of being heard should be given. Innovative also, I think they have decided. Innovative was the first case and maybe the other cases also, yeah.
See, sir, principles of natural justice is a wide subject. We can...
Specifically talks about the notice to be served, and without that serving of the notice, adjudicating authority cannot deny.
Cannot admit that.
Cannot.
Correct.
At what stage? Only at admission stage or at
See, when I file my application, I am supposed to issue notice forthwith. Whether you get it, don't get it, no. But mostly, most of the NCLTs ask for tracking report and all and find that it is given. Second is that this notice is not new to you and I am not coming to surprise. Before that, I would have recalled my loan. I would have come to you several times asking, please pay, please pay, please pay. It is not a surprise to you.
Even then also NCLTs are allowing, if the advance notice has been given to you, suppose, and then you are going to NCLT that I should give some time. Again, they are allowing some time, 1 week, 2 weeks, that okay, you prepare. Though the advance notice is with you from last 20 days, they are allowing you to take some time and give your reply.
No, sir, they are giving enough and more enlarged time.
Yeah.
They are very magnanimous.
I think the notice was given as a public notice, not as a notice in specific. I think order needs to be analyzed.
No, what we do is we give the booklet. It's paper prepared on booklet. We send it to by post and intimate them. That is what I am supposed to do. Other one, public notice is post moratorium, simultaneous moratorium and public notice. Ideally, in section 9 cases, you should not appoint IRP. Get it admitted. Wait, the other guy will come and pay you. If you appoint IRP, then whole things goes out of your hand.
But before appointment of IRP or admission of petition, is it different concepts? Like we can settle in between? I think no.
See, if IRP is appointed, then the court will be compelled to issue moratorium.
Right.
So if IRP is not there, no moratorium. Meanwhile, you can discuss and close it.
Okay, yeah.
But it's treated as after admission actually.
After admission, they have got vast powers. 65, if you go through 65 of the code, they have got wide powers. Their discretion is so large. And as I told you, discretion often is used as tool for discrimination.
Sir, how to interpret the word day? Say, under the IPC, there are different timelines mentioned. 10 days, 7 days, 4 days. So day means?
Day is Indian Standard Time from the date the NCLT passed orders.
So excluding holidays or?
No, holiday is not excluded, no.
So 10 days to reply the demand notice means on the 10th day we should send that notice by post or whatever, or that should reach to the other guy.
Yeah, notice can be, reply can be in electronic form also.
If it is in the hard copy and sending by courier.
Yeah,
then
subject to you have the IP path very clear. 10.1, whichever system you have generated this thing, send the mail, that should be kept. It is not that notice, reply should be only in paper form, electronic form also.
Can I exclude working holidays?
holidays cannot be excluded.
If you want to take the risk, yes.
That's great. In fact, if the other questions are there, we can take offline outside this room because we are already late. And thank you very much for coming here. Thank you, Sajid and Raghu, being a part of this panel discussion. Thank you very much. And we'll keep on doing these kind of programs and inviting you for the same. Thank you.
Thank you panel members for sharing your expertise. Thank you participants for your active participation. So I would now request Raghu sir to please give away the mementos. Prashant. Mr. Prashant.
Please. Working will be better than before.
Mr. Sajid to please give over the memento to Parvesh. Mr. Parvesh.
Now I am on the other side of our But he is confused. Who is giving to whom? Subject to you.
They'll capture the name.
Capture the name.
Mr. Parvesh, Raghu sir. Prashant, Mr. Sajid. So we'll be sharing the feedback form online. So we would request your suggestions, and please join us for the high tea.